Good evening, everyone. We're going to call to order tonight's Township of Bernard Zoning Board of Adjustment. The first item on the agenda is the flag salute, so if you can stand, please do so.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In accordance with the requirement of the Open Public Meeting Law, notice of this special meeting of the Board of Adjustment of the Township of Bernards was posted on the bulletin board in the reception hall of the municipal building, Collier Lane, Basking Ridge, New Jersey. It was also mailed to the Bernardsville News, Whippany, New Jersey, the Courier News, and Bridgewater, New Jersey, and it was also filed with the Township Clerk all on August 27th of this year. And it was mailed electronically to all those people who had requested individual notice. The following procedure has been adopted by the Bernards Township Zoning Board of Adjustment. There will be no new cases heard after 10 o'clock tonight, and no new testimony heard after 10:30 tonight. Ms. Kiefer, can you do a roll call for us?
Certainly. Chairwoman Janiers.
Here.
Ms. Baumann, Ms. Padici, and Ms. Pakhtar are all recused and not present this evening. Mr. Cambria has indicated he will attend, but he will be a little late. Mr. Kraus.
Here.
Mr. Tancredi.
Here.
Mr. Halverson.
Here.
Ms. Herrera.
Here.
Mr. Sobieski.
Here.
Mr. Quinn.
Here.
Mr. Schley.
Here.
And for the record, Ms. Kiefer is present. Madam Chair, you have a quorum. You may proceed.
Great, thank you, Ms. Kiefer, and thanks to everyone for coming on this special meeting. Right. Next on the agenda is the approval of resolutions. The first one was ZB 24003. I think it has been circulated in advance. It was Antipastas Block 2603. Does anybody have any comments or edits or motion on that one?
And Madam Chair, you are eligible. Mr. Kraus, Mr. Tancredi, and Mr. Halverson are eligible on this and the next two resolutions.
Great, all three.
Madam Chair, I move to approve the resolution as drafted.
Great, thank you.
I'll second.
Thank you, Mr. Kraus.
Mr. Kraus,
Yes.
Mr. Tancredi,
Yes.
Mr. Halverson,
Yes.
Chairwoman Janiers.
Yes.
Thank you.
Thank you. The next resolution was McFadden, which was ZB 24011. Same drill, it was circulated. Any comments or edits or motions?
Motion to approve.
Thank you, Mr. Halverson. Is there a second?
Second.
Thank you, Mr. Kraus.
Mr. Kraus,
Yes.
Mr. Tancredi,
Yes.
Mr. Halverson,
Yes.
Chairwoman Janiers.
Yes.
Thank you.
Thank you. And then the final resolution was Cook, ZB 24012.
I'll make a motion to approve as drafted.
Thank you, Mr. Kraus.
Second.
Thank you, Mr. Creedy.
Mr. Kraus,
Yes.
Mr. Tancredi,
Yes.
Mr. Halverson,
Yes.
Chairwoman Janiers.
Yes,
Thank you.
great.
And Chairwoman, would you like to have a vote to excuse the absences of our three recusals?
Yes, will we have a motion for, there's three who are recused? We'll leave Mr. Cambria to the side for now, expecting him.
So moved.
Thank you. Second?
Second.
Thank you.
All in favor?
Aye.
Opposed? Abstained? Thank you.
Thank you. And then, as we mentioned, we do expect Mr. Cambria to join us as we go here. We'll announce when he joins us here. Next on the agenda is the public hearing for signature acquisitions, which was continued from August 7th, 2024.
Madam Chair, I'll just quickly point out, the applicant did renotice for this particular special meeting tonight. Published notice both in two different newspapers, Burnsville News and the Courier News, on September 5th, and also sent notice by certified mail to all property owners within 200 feet of the subject property on also on September 5th. So notice is good. The board continues to have jurisdiction.
Great, thank you.
Of course.
And I think where we left off, Mr. Laird, you were going to have a cross of the planner. Is that the right word? Cross? Yeah.
Cross-examination.
Cross-examination of the planner. So I think that would be a good place to start.
First of all, thank you for, I just wanted to say, is it okay that I not wear a jacket? Because I'm just still wearing a sling.
We'll let it go this time.
Thank you. I'm getting there. So I wanted to just say to Mrs. Holmquist, I appreciate her flexibility and her ability to come here tonight. I know that we had to juggle some schedules, but I do appreciate her being here.
So I guess-
Spot, Madam Chair, or?
Are you ready, Mr. Lara?
Yep. Real quick, Ms. Holmquist, you're a man under oath. Your license is still in good standing?
Yes, it is.
Okay, still, okay.
Yeah, sure.
Thank you. That's actually a good reminder. We've had several reminders from members of the public and other members of the board to remind everyone to speak directly into the microphone so that we can pick up everything that you're saying. And actually, this is good timing because Mr. Cambria is joining us, so
Oh, perfect.
if you could, we can just give him a minute to get situated, then you will not have missed anything. Yeah, I know. The pressure.
I was wondering if Mr. Schley could pull down the screen for the 3 exhibits that were presented by Ms. Holmquist at the July 11 meeting.
I see them here.
You got it.
Yes.
I will get there in a moment. I just have some
Yeah, I
other
think
questions.
they're loaded here. I
Okay.
see them.
Okay. I will get to them in a few moments. Thank you, Ms. Holmquist, for being here, and I just have, it won't take terribly long, but I have some questions.
Yes.
In terms of, based upon the testimony you had given in July, there were some things that came to my mind about some of your qualifications, and I just have to ask initially, what percentage of your practice is devoted to objector work?
I'm going to guess maybe a quarter to a third.
Okay, and how about applicant work?
It's pretty equal, about a third.
And how about municipal work?
It's about a third.
The other
Yeah,
third,
yeah.
okay.
We try to
And
spread
how many-
ourselves equally. Yes.
Okay, and how many municipalities do you currently represent?
Currently, 2 right now. Yes, the Borough of Riverdale and the Borough of Englishtown in Monmouth County.
And how many master plans have you prepared in the past 5 years?
My firm has done 2. That would be a master plan amendment for the Township of Livingston and a master plan reexamination for the Borough of Riverdale.
Okay. You mentioned multiple times in your testimony on July 11th that you have 40 years of experience in sitting through hearings, yet you testified that you received your planning license in 1990, which is only 34 years. What accounts for the other 6 years?
I graduated college, we'll go way back, 1985, and I started working for a firm called Malcolm Kassler and Associates. I don't know if you know Jason Kassler, but he's Malcolm's son, and I worked there for 5 years. At the same time, I was going for my Master of Urban Planning. So I left that firm. I worked there in 1985 to 1989 for Malcolm Kassler Associates, and I attended planning board meetings, although I was not licensed. So if it called for license testimony, a principal of the firm attended and gave that. But I worked on master plans, housing plans, site plan reviews, et cetera. And then I received my Master of Urban Planning in 1990, and then that is when I went to work for an engineering firm that used to be known as Vollmer Associates. It's Stantec now.
Okay. Several times during your testimony on July 11, you focused on Lot 2, which is the adjacent lot, and you ultimately determined that a D2 variance was
D1,
not required
Jeff, you're right.
on that lot.
D1.
But that but 2 D1 variances were required. Do you recall that testimony?
Yes.
Okay. One of your planning theories for D1 relief had to do with the fact that under section 21-21.5 of the Berners Code, private access through non-residential uses shall not be through a residentially zoned lot. Do you recall that testimony?
Yes.
As a planner, when testifying about zoning ordinances, the zones are normally broken down by principal uses, permitted uses, prohibited uses, accessory uses, and conditional uses. Would you agree with that generally?
Yes.
And Section 70D of the Municipal Land Use Law speaks of a use or principal structure in a district restricted against such use or principal structure. Is that correct?
Yes.
So a single-family dwelling would be allowed in the R2 zone, would it not?
Yes.
You characterize the public utility on Lot 2 as a principal use. Do you recall that testimony?
Yes.
Are you aware that Section 19 of the Municipal Land Use Law, which guides boards of adjustment and planning boards, states, quote, "This act or any ordinance or regulation made under the authority thereof shall not apply to a development proposed by a public utility for installation in more than one municipality for the furnishing of service if the public utility receives approval from the BPU."
Okay, I'm looking at the section of the land use law that you're citing, and it's 4055D-19,
Correct.
appeal or petition in certain cases to the Board of Public Utilities.
Right. That's correct.
And which, it's
Well,
very lengthy. Which portion of this are we calling attention to here?
Well, the portion that says, "This act or any ordinance or regulation made under authority thereof shall not apply to a development proposed by a public utility for installation in more than one municipality for the furnishing of service."
Okay, that's the second paragraph.
Right. Would you agree that the BPU, in all likelihood, approved a public utility for electric crossing much of the township and into other municipalities?
I would assume that, yes.
Okay.
Mhm.
And Title 48, colon 2-13, dealing with the powers of Board of Public Utilities, provides at Section A as follows. The board, meaning the Board of Public Utilities.
Can I just interrupt? That's not, you're not out of the municipal
I'm not
land
at
use
the
law. You're
municipal
out of
land use
something
law.
that I'm unfamiliar with.
Yeah.
Okay, so I'll,
But it states that it
attention.
shall have general supervision and regulation of and jurisdiction and control over all public utilities as defined in this section and their property rights, equipment, facilities, and franchises, so as far as may be necessary for the purposes of carrying out the provisions of this title. So based upon my read, is it still your opinion that a public utility is a principal use in the R2 zone?
yes, that is, I'm a planner, so I look at the uses of the property. I've never seen or reviewed the section of law that you're citing, and it's not something that I think I would.
Well, it's part of the municipal land use law that says utilities are not subject to the jurisdiction of, under the municipality, under the municipal land use law. So again, is it your opinion that a public utility is a principal use?
Yes, it is. As a planner, that is a principal use
That's your
on that
answer. The
property.
other principal use you said existed on Lot 2 is the access easement which serves Lot 3 and several other lots to the east. Is that correct?
Well, I think my testimony, if I could recap that, was that a road is proposed to connect the subject site to Allen Road, and it will traverse the residentially zoned parcel.
We'll get to the use of proposed
Mhm.
in a few minutes. Does that access easement serve Lot 2?
There is an existing easement, yes,
Does it serve Lot 2?
yes.
Is there a driveway that cuts off of Lot 2 to serve a house on Lot 2?
Cuts off of lot, there is no house.
Okay, so how could it serve Lot 2?
It exists. The easement exists, there is a paved surface, and it connects Allen Road to the subject site.
I'll move on. The other D1
Okay.
variance you testified about was that the access road on Lot 2 services a non-residential zone, correct?
The subject site is in the E2 zone, so that is a non-residential zone, and Lot 2 is in a residential zone.
Well, during your testimony, you said that you had looked at the resolutions from the 1980s. Do you recall that testimony?
Yes?
And on page 133 of the transcript from the July 11th hearing, you stated, quote, "As I understand it, no variance was ever granted for that," and by that I mean the access on Lot 2, "and the prior development was office, and it was office in conjunction with a subdivision from the 80s that basically hatched, if you will, all the office development." Do you remember
Yeah,
saying that?
yeah.
Could you clarify what you mean by the word hatched?
I reviewed the resolutions from 1987 and 1986, and I did not have the maps that were approved in front of me, so I was going basically just off the language in the resolutions and my knowledge of the properties in the study area.
So
And-
how much real time and effort did you take in reviewing those old resolutions, maps, and other documents? In other words, to use an analogy, did you just stick your toe into the pool, or did you do a deep dive into the history of the access road?
Well, I spent a lot of time, and I'm very thorough in my work, and when I form conclusions, they're based on the facts that I have in front of me.
Let's take a little bit of a deeper dive. I have copies from board members.
May I ask, are these
Yep.
exhibits that have
Copies.
been part of the
Copies
application?
for council, and I have copies for members of the public possession.
But are these exhibits that are part of the files application?
How about me? Mr. Verley and I said that I had copies for everyone else.
Hey, Jeff, real question though, were these submitted ahead of time, or these are introduced?
No, this is
new
as
exhibits?
part of cross-examination, but these are all public records.
Okay,
These are all public records, and none of it is new, meaning that I've created it or anything else. They're all public record.
for
And,
the record purposes, for this record,
correct,
it's an exhibit, so.
it's an exhibit. So I would like to call it A6.
Say six. Does that, Cindy, does that track with?
Correct.
Okay.
My objection, though, is that these exhibits were not submitted ahead of time, and I will also say that we submitted an open request over a year ago for all files that were pertaining to these resolutions, so if these are new public records that we did not have access to, and if these are new public records that were not part of the application, it seems unfair this evening that they be considered as part of evidence.
Okay. I would think that this is being submitted, we haven't heard how he's going to use this, but I
Right.
would assume it's coming out of
Yes.
the planner's testimony and it's
Right.
presented for cross, so.
I only answer what Ms. Smith said by saying that they're public records. I did my homework, I did a deep dive, and I wanted to just talk about them because they really respond to certain things that were said.
My question, though, is where were these documents obtained from? Is it public record?
Will you
I-
give us the background on the document? we got?
Yeah, they're municipal records that I had asked for, and they were provided to me. Just as Ms. Smith's entitled to look at all the entire history of that area for the past 40 or 50 years, which is really important.
Okay, thank you.
So how much, so
Mr. Lair, I'm sorry, so this is Exhibit A6.
A6.
Do we have a title for this?
Yes.
Zoning map? Highlighted zoning map?
It is a 1974 zoning map of the Township of Bernards. And what I would do is ask Ms. Holmquist, do you see where, and I did highlight that, the yellow area. Do you see the area highlighted in yellow?
Yes?
Okay, and can you tell us what that property, what it's zoned, all of that property which forms the area that we're talking about, lots 2, 3, 4, 5, all of it? Can you tell us what it's zoned? In
Okay, it's
1974.
very, okay, this is the first time I'm seeing this map. It's really difficult to read the street names on here.
Would it
Okay,
be
so,
surprising if I told you it was zoned commercial?
well, It looks like the dots of commercial. Can I read the names of the streets to be certain of where we are? No, I can't.
Okay. I think the board knows where the property is, public knows where the property is, and it's zoned commercial.
Is that, I just object, is that Mr. Ware's testimony?
Well, I would ask any board member to tell me that I'm wrong.
Is that a representation? It's not testimony, right?
It's representations. I'm now going to introduce to you Exhibit B.
I think you mean Exhibit A7.
I'm sorry, A7.
You can ask.
When did you get this document that you couldn't give it to us before 3 minutes ago? When did you get it in your possession?
Probably a month ago.
And you can submit it? But I'm just wondering why.
Well, I was going to submit it and talk about it during cross-examination.
But everything else
It's
we
all
get-
It's all public information.
Usually we get everything beforehand, so we can just give it.
Well,
Don't,
they're
I
not
mean, everything.
marked because.
I'm just
He can
wondering.
bring exhibits real
I'm
time.
just wondering.
Mhm.
Why- why is it different? I should ask him.
Yep, yeah. Just to be clear, I didn't prepare
Whatever you
anything.
wanna do.
I didn't prepare it, my engineer didn't prepare it, it's all public document. I didn't prepare anything, Mr. Kraus. They were all
I
public
didn't ask
documents.
you if you prepared it, I said, when did you receive it?
Okay.
When did you pull it? When it was in your possession? You
Okay.
responded, and that was all we needed.
Okay, thank you.
Mr. Laird, Exhibit A7.
A7.
Get a title for this, please. For the public settles down.
Ms. Holmquist, can you, you know what this document is?
Well, I can.
Can I just ask the public to please silent, it's really hard to hear, we're doing our best to hear the testimony, so I can ask the conversations to be held at a minimum 4-0.
The title is Preliminary and Final Subdivision and Site Plan Approval, Science Management Corporation.
Right,
And the applicant was Joseph Hilton.
right. If I told you that the 1983 approval was for minor subdivision of what existed then as Lot 7 in Blocks 177, in order to create two lots, one of which was to be used for a medical research facility to be built at 140 Allen Road, and the other to remain vacant, namely current Lot 2. Would that ring a bell? Would that sound familiar?
Okay, so when I look at this document, the block and lots are different than they are now. The block number is different.
I'll get to that.
And it also refers to E1 and E2 zones and L14. So the zoning map that you had me look at first does not correspond to the zones that are listed in this resolution. So I'm,
Let's get there one step at a time, okay?
okay.
So I'd ask you to take a look at paragraph, page 4, condition number 15. And maybe you could read it out loud, or if you'd like me to read it, I'll read it.
Well, why don't you read it, because there's 2 pages ahead of it that I haven't had a chance to look at.
It says, "At such time as the remainder of this tract or other property to the east shall develop, combined access for all the properties shall be constructed. Site plan contemplates use of a portion of the property in the vicinity of the sewer line easement to be used for combined access along with adjacent properties. The applicant shall make such modifications to their own access as required by the township engineer to bring about permanent access to the SMC facility and shall allow the use of their property for combined access. Should additional easements be required to construct the combined access, then the owner shall agree to granting such easements, assuming the request is reasonable." And you see that the approval was granted by the Bernards Township Planning Board and not the zoning board, correct?
No, I'm not clear on that. Where are you telling me that I see that?
So take a look at the front page, and it says, look at the third
Whereas, yes,
clause.
whereas the Planning Board of Bernards Township, the last paragraph on page 1.
Correct. And then if you look at, yes, that's correct. That's where it states the planning board. So, would it be fair to say that the access road was created by the planning board in 1983? In other words, it did not exist before the 1983 approval.
I don't know that I would feel 100% sure. And I say that because in the paragraph that you picked out on page 4, it just talks about, contemplates use it. And again, I'm at a disadvantage because I haven't had even a chance to sit down and read this entire document. So I don't know what it says before this. But I would feel uncomfortable agreeing with that because I don't know what else existed. I'm not looking at a map of the property.
So let's give you a map, okay? So the next exhibit I have is A8.
Thank you.
Thank you.
Just as an objection and clarity on the record, I asked previously if A6 had been submitted with the application. I just want to clarify that A7 and A8 also had not been submitted.
Ms. Smith, I'm sorry, could you come up to a microphone and voice that out, please?
So I just want to clarify for the record, I previously asked for confirmation that A6 had not been previously submitted with the application. I just wanted, for the record, clarification that A7 and A8 had not been submitted as part of the application documents.
Mr. Blair, could you speak to that, please?
They're public records. They were not submitted as part of the application. I was able to receive them through Oprah request, through my own due diligence, but they're public records. Ms. Holmquist.
Yes, you've given me another site plan, I guess this is, right?
Let me get to the question.
We don't have, well, we don't have all the sheets. You've selected, I guess there's nine, more than 9 sheets. There's many sheets to this site plan submittal, and you have selected 3. And it's,
Right.
again, it's very, I'm trying to read the titles to see which sheets you've picked out. Okay, one is subdivision plan, so that's sheet 1.
Mr. Lara, I assume you're going to take us through these sheets.
I will if I'm given the opportunity. So if I could tell you that this was the subdivision map that created the 2 lots that one was for 140 and the other one was the remainder parcel. So you have what was identified as Lot 1, where the new building was for science management in 1983. And then you had the other larger lot to the west, identified as Lot 2, 40.235 acres. And do you see a access road coming down from Allen Road all the way to 140 Allen Road site?
The map that I have, I'm looking at L1, and there's yellow highlighting on portions of the map. And where I look at what adjoins Allen Road, the yellow highlighting seems to indicate, I don't know that it shows a road. It might just be the easement. I'm not
Whether you
clear.
call it an easement or a road, let's call it an easement.
Okay, I'm sorry, but I can't read the labeling. So, you're asking me to assume things, and I don't think that that's what I need to be doing up here.
Well, in July, you stated that you looked at records from 1985 and 1986, and that there were no variances granted. I don't think what I'm getting at is you didn't look far enough into the history to see that before that, the access road was actually required as part of a planning board approval, which I'll get to. So let me just get further. From these two documents, is it plain to you that the planning board in 1985 approved the one, I'm sorry, let me go back. Based upon the 1983 site plan that's before you, does it surprise you that this was all originally one large lot?
All one lot.
Right, before it was subdivided in 1983. And that map is the subdivision page, one of them is the subdivision page that breaks the two lots out. Would it surprise you that this was all one large lot at that time,
Well,
before the subdivision occurred?
Well, I see on the first page where it lists the sheets, sheet L4 is site survey. And I don't think we have that, do we? We don't have the site survey. And I really, you see, I am reluctant to make assumptions on incomplete information.
I understand that I'm putting you right on the spot here tonight, but you stated on the record that the access road is proposed, number one, and you also stated that you looked at the resolutions from 1985 and 1986. That's all you said you looked at. But if you look deeper, you will see that easement existed in 1983 and created two lots.
I went as far back as 1986. I'm looking at my notes from the resolutions that I reviewed. So it was 1986.
Would it surprise you to know that the access road was built across a single parcel of land, which was then known as Lot 7, which, while it may have been constructed on land zoned residential, it was a condition of the 1983 Planning Board approval for the 140 Allen Road Science Management Building.
Again, I have to object. Mr. Lair is putting facts into the record that were not put into the record by any other person that testified, not his planner or anyone else.
This is cross-examination. I'm entitled to ask questions.
But as far as establishing what Mr. Lair is saying as facts, they cannot be established as facts based on his line of questioning.
It's a public record.
Yes, but you're not asking someone to verify the public record. You are saying this is what the public record says.
I normally do not see planners presenting the kinds of exhibits, lawyers present these exhibits to show the record. And your client testified on the record that the access road was not created by variance. Well, it wasn't. I'm going to show you why.
Right, it is not for the attorneys to show why. Respectfully, what has happened here is the planner that was presented on behalf of the applicant testified that a D2 variance was required. The applicant submitted an application that provided the prior resolutions and did not provide these resolutions. And now during cross-examination, Mr. Lair is trying to get Ms. Holmquist to talk about facts that were not previously in this record, were not part of this application, and I have to object to the evidence coming in this way. If Mr. Lair would like to recall his planner to walk through certain documents and present them to the board, that would be the proper way for this board to evaluate actual facts and not Mr. Lair's summary of documents.
So I would ask just
I don't agree.
question marks at the end of whatever you're asking her.
I'm going to just continue, but I understand her objection, but I don't agree at all. that it's proper cross-examination, and in a proper cross-examination in a land use context, the rules of evidence are not strictly adhered to, and I'm allowed to present whatever exhibits I want to refute what she has said, and these are public documents. And I'm gonna take it slow. I'm not gonna push them through. If the board needs time after this hearing to review them, then so be it. I do not think I need to recall my planner. May I
Mr. Mayor,
continue? Yeah.
Could I ask you, do you view this as a matter of law or a matter of fact, being that
It's-
it's a public record?
I view it as a matter of fact. Yeah.
I would just ask you to try to keep the questions, because you are kind of leaning into more statements, representation.
And just so I'm clear and just so I'm clear as I'm listening to this in terms of the matter of fact versus the matter of law versus the opinion, the matter of fact are the papers we have in our hand, right? As distinguished from the characterization from the papers, meaning these are the facts. Is there any other?
That's what you're here to decide, is whether or not that it's,
Yep.
the representations that Mr. Blair's making are true. You're the fact finder as the board. I'm sorry. The board is here is the fact finder. We're here to decide what the facts are. So, I think when you're asking is it a matter of fact or matter of law, what they're arguing about is whether or not Mr. Blair can ask these questions. That's a matter of law. Whether or not the representations he's making or the statements made by the objector's planner are true or not, that's for the board to decide. Those are matters of fact. Does that make sense?
I think so.
Okay.
We'll see.
Okay.
We note your objection, Ms. Phil Smith. I want to hear what Mr. Lair has to say, because I do feel that, you know, he's been arguing for a very long time that D1 is not required on that access, and your planner suggested that it is, so I'd like to give him a little bit of leeway in terms of the cross with respect to that question.
I'm going to move just farther. In order to, I'm going to provide you with a document which I'm actually just going to let you take a look at. This would be A9, and you can have several copies. I'll give the board several copies.
Which document is this?
This is A9.
Okay.
This is A9 for you.
And Mr. Lair, before we go any further, I want to close the loop on Exhibit A8 for the purposes of the record. So this is Exhibit A8. This is a 4-page set of plans consisting of a cover sheet, sheet L1, sheet L7, and sheet L8 of a, what is this, a subdivision plan set? I'm just trying to get a title for it. So we
That's
understand
correct.
what it is. Okay, great. And these are, what's the date on this plan set?
I believe that it's 1983, I believe. If you just give me a moment, I thought it was
I seem to see a June
June. That's correct.
24th, 1983? Does that
Yes.
sound correct to you?
June of 1983.
Okay, thank you.
We need one more of these down here from us.
Do you have one more of this A9?
Take one down if you have it.
Actually, can we get 2 copies?
Sure,
Oh, I thought it.
I have,
You might have been,
Okay.
I have extras.
Okay,
wait,
thank you.
did I put it up here?
We got a
Lot
couple
to keep
more.
track of tonight.
Okay.
So-
There's 2 more.
Ms. Holmquist, do you know what this document is that's in front of you?
It's entitled Deed of Easement.
Right, I refer you to the 4th whereas clause in this deed of easement, and can you read, I'll read it, but it says, whereas in connection with such construction, the municipality has required the creation of parcel A and the remainder of lot 7, which is the larger lot, block 177, of a single roadway system to provide for ingress to and egress from parcel A and the remainder of lot 7, block 177, onto Allen Road. So the next one I'm going to show you is one, this one, if you look at it, is from the grantor, the person giving the grant, is from Raymond Von Cullen and others to Joe Hill, SMC Associates. SMC Associates is the same name on the subdivision plan that I had previously given you as A8 as the applicant. So this was an easement that memorialized condition number 15 that required by the municipality an easement, a cross-access easement, to build the cross-access easement that we now know as the Lot 2 access easement.
And again, I have to object, these are not facts in the record. There's been no one to testify that this document, A9, is linked to any of these other documents.
With all due respect, Ms. Smith, your client stated on the record, I did my homework, and that I looked at all the records, and I asked, did you do a deep dive? And she said, I did as deep a dive as I could, or something to that effect. Well, I don't think she did. And the truth of the matter is that the access easement was created in 1983 by way of a mutual access easement, and it was required by the municipality. So your argument that D1 relief, it all goes to that. It all goes to this. And if you let me finish, I'll just get there.
I would just note for both counselors, the board understands that any statement from Mr. Lair is a representation. It's not
Correct.
sworn testimony, and it's
Correct.
not given away.
Absolutely.
So.
But unfortunately, I can't cross-examine Mr. Lair.
So let me just show you the next document, A10.
Do we even get an official title for A9, Mr. Lair? This, what is this, deed of easement dated August 5th, 1983?
Correct.
To Lot 7, Block 177? That's what we're calling it.
And Ms. Holmquist, I did not give you a copy.
I was wondering about that.
So what I'm showing you is the opposite side, where the owner of Lot 2, what is currently Lot 2, granted an access easement to the owner of the 140, the balance of the land where 140 was built, 140 Allen Road. And if you, again, the fourth whereas clause says, whereas the municipality has required the creation over parcel A and parcel B of a single roadway system to provide for ingress and egress from parcel A and parcel B onto Allen Road, and in order to effectuate the common ingress and egress roadway system here and above described, grantor has agreed to grant to grantee as the owner of parcel B a non-exclusive easement over that portion of parcel A hereinafter described for the purpose of providing ingress to and egress from parcel B onto Allen Road in exchange for granting a similar easement to grantor over a portion of parcel A. So I'm getting to the point where I'm telling you, the board, I'm representing to the board, that the deep dive that was done really didn't disclose that the municipality required this cross-access easement in 1983. And if I'm going to hear from Ms. Smith that, well, I did my homework, well, maybe she didn't do enough. And I'm saying to the board, we keep talking about this as a variance. I'm submitting that it's not. Let me just keep going.
Well, can I make a response? I'm not an attorney, but when I have seen easement agreements, there is usually an exhibit map attached to them that clearly identifies the properties that are being, given in consideration or part of that. And the reference was to, I think, parcel A and parcel B. And when I'm looking at the subdivision map that was distributed as an exhibit, I don't see parcel A and parcel B on there. So with what has been selected out of these easement agreements, having no map attached to them, and having only a subdivision in front of me that doesn't reference, as far as I can see, because it's very difficult to read this, if not near impossible, I do not see a parcel A or B. So I do not have anything in front of me that leads me to believe that this pertains to the yellow coloring that was distributed by Mr. Lair.
It's a fair enough point, I understand, I'm just gonna move on.
Oh, okay.
Can you? Well, I mean, I can argue, but I'm not gonna do that. I
Okay.
wanna move on.
Okay.
Members of the public, please.
Right,
Decorum.
the next one is A10, and,
Right, Mr. Laird, are you referring to the A10 you gave us?
Is this
or-
a new one?
no, that's I'm sorry, that would be A10, this is A11, what I'm gonna come up with. So there is a website called Historic Aerials. Are you aware of that?
Yes, I am.
Okay, and it's a public access app, correct?
Yes,
And you use it as a planning tool.
on occasion,
Okay, so if I tell you that I did that
as a lawyer, okay.
as a lawyer, and I found 1984 aerial of this area,
Okay.
and I show it to you, are you going to object and say, well, it's hearsay? Or are you gonna say that it's permitted? I'm gonna just present.
I don't think I said hearsay. I don't think I said that. Oh, so you didn't pay for the image, Jeff, huh? I see it has the watermark on it.
Let me have it. Counsel?
Oh, my.
Okay, so this is
This is 11?
A11.
Right?
Okay, so- Page-
So do you see the access easement on this historic
Well,
map
okay.
from 1984?
All right, you've handed me 3 pages, right?
Okay, so
And-
on the first page,
Uh-huh.
Something's
Something's highlighted in green, right? Or
Right.
yellow, green. Mm.
and I can tell you that I did that, but it follows a line from Allen Road where it bends, where that little semicircle is, all the way down to the 140 building and crosses over what is now Lot 2. That's the access easement, but that's the way it existed in 1984. I'm telling you that this is my research.
So what you,
Next page is-
I have a question.
well, the following 2 pages just are the same thing, but just in a different configuration.
I'm
One
still-
shows
I'm sorry.
now, so I'm
Like,
leaving C.
what am I
Mr. Laird,
supposed
hold
to
on,
be
sir.
listening to? What, I'm just confused as a board member, what it is I'm hearing right now. But I thought we were doing cross-examination, like the questions of the, I'm just confused. Can I get a little bit of clarity on what we're doing?
Sure. I'm sorry, what I'm doing is trying to impute the statements made by the applicant's planner.
No, I meant with this document.
Well, that's a historic record from off of a public document, a public application that anyone, or me, or Ms. Smith, can go to and find out what existed on an aerial map in 1984 at that area, in the area that we're talking about.
But when, I'm just confused, when you're talking about what it is that I'm looking at, am I supposed to take what he's saying as
No.
the
You
truth?
put-
He's
you put
making representations. He-
I'm making a representation, you put as much weight onto it as you want,
Right.
but I can tell you that it is my representation that is the access easement.
Okay,
It's not sworn testimony. It's just a representation.
thank you for clarifying.
Mr. Lair, when you looked at these images, were they clearer than the ones that you're presenting to us? Because what I'm looking at, I can't tell what most of these images are. The deeds are self-explanatory,
will-
but the images, it's very difficult to see what we're looking at. They're unclear.
It's a good
The
point.
maps are
I will
unclear.
provide you with an unhighlighted version, and all opposing counsel and members of the board to show you the highlighted version. So you can make your own decision as to whether that access easement existed in 1984. Yeah, I mean, I don't want to ask you to do this, but if you have a computer, you can find it on historic maps, the application, and you'll see what I'm talking about.
Is that permissible? Like, are we allowed to go and?
As long, much like if you were driving by a property, you'd have to put on the record that you drove by, as Ms. Padici does actually.
I get the drive-by, but to being directed to a website, like we can go.
Similar thing, if you look at this up online on your own and you're gonna use it in your calculus when you decide on this application, you have an obligation to put it on the record that you observed it to give the applicant plus objectors an opportunity to respond to it. But I think as a practical matter, it might be a better idea if Mr. Lair were to provide better
I'll provide
copies.
that, yes.
Thank you.
A12, I think I'm at A12.
Thank you. Oops, I
Sorry.
got it, thanks.
I'm gonna give it to you.
Oh, Mr. Lair, I have an extra here, if you need it.
So, Ms. Holmquist, can you tell the board at the bottom of the first page what the title says?
Preliminary and final site plan and minor subdivision approval, Allen Center, Bigelow-Quinlan Properties, Inc.
And at the top of the page, what does it say?
Planning Board?
Correct. And I'm asking you to, well, let's just go on, and I'll get you the other exhibit so that we can read them together.
So, Mr. Lair, just to be clear, Exhibit A12 is a copy of planning board minutes dated, or from the meeting, June 27th, 1985.
That's correct.
Thank you.
Thank you.
Can you tell us, Ms. Holmquist, what this exhibit is?
The map?
Yes.
Well, the title says subdivision plat. Now, what it says under that, I cannot read it. It's blurred on my copy.
Okay. So, it says subdivision plat, Carlson and Associates, Richard W. Carlson. And it has a date on it of January 18, 1985. And can you tell us what this map shows you as a planner?
The zone boundaries are delineated on this. Very difficult to read. There's a number or something in a circle. I don't know if that's the block and lot. I really cannot read it. I see Allen Road at the top of the map.
So do me a favor, go back to the resolution and look at finding of fact number 2 on page 2. Because the two go hand in hand. They reference the same map. The resolution references the map that is in your hands. And finding of fact number 2 says, the applicant proposes the subdivision of said property along the zone line in 2 lots and the construction of an office building in the E2 lot after subdivision. All is shown in accordance with plans entitled Allen Center, Bigelow-Quinlan Properties, Township of Bernards, the date is March 19, 1985, prepared by Chapman and Biber, consisting of 14 sheets. I've only given you one sheet, which is the subdivision sheet, but
Okay, so one thing I want to point out in the paragraph that you just read, paragraph 2 on page 2 of the resolution, it says prepared by Chapman and Bieber, I don't know how you say it. The company, in the title block of the map that you gave me, it says Carlson and Associates. So you stated just now that this map goes with this resolution, and I don't know about that. And even before that, in the first whereas, it says Chapman and Bieber. So I don't know where it references Carlson and Associates subdivision plat.
Yeah, it
So
does
to-
say on that sheet, on the
Well,
map,
I'm,
/
based on what you've handed me, I'm not going to agree that that map matches this resolution.
All right, fair enough, but it says owner, on the map, it says owner / subdivider, Bigelow Quinlan Properties, Inc., 41 Schoolhouse Road, Lane, Morristown, New Jersey. Is that correct?
Yes.
Okay. So, from these two documents, is it plain to you that the planning board in 1985 approved the 150 Allen Road office building and the further subdivision of the property along the E2 and the R1 zone boundary lines?
Okay, well, as I said, it's very impossible for me to read the block and lots that are on this subdivision plat.
Okay, I did get them together from the town, so they were in the same folder, but I'm gonna put on the record that they are part of the same subdivision. If you want to find that I'm wrong, then please do so.
That's your assertion, Mr. Laird, that these are part of the same thing? Again, that's a representation by council.
Correct.
Sworn testimony.
So, would it be a true statement that it was not until 1985 that what is now known as Lot 2 was created?
All right, I'm looking at the resolution that we're speaking of right now, right? And you're talking about Lot 2. The block and lots are old, you know, I guess they were revised at some point. I don't know it says property shown as lots 7.02, 10, and 14, block 177. I don't know if one of those became Lot 2, and the map that you gave me, I really cannot read the numbers on here.
Right, so, but you do see the zone line, R3 zone and the E2 zone, and they ultimately became the new lot line, because it says zone and new lot line. Do you read that on the map?
Yes,
Okay,
yes, I see that.
all right. I believe it was your opinion that this access road, quote, simply occurred. Do you recall that testimony?
Simply occurred, no, I don't recall that choice of words, but
I can tell you those are the words in
Okay.
in the transcript, but I'm not.
fair enough.
Would you now agree that the access driveway lawfully exists on Lot 2?
You've produced documents that show an easement. I don't know, these documents that you put forward tonight, I don't know what the zoning was. Obviously, it was different because it says R3, right? And it's R1 now, right? It's R1 now.
Correct.
Okay, so
Still residential.
no variance was granted. That was what,
I never said that.
yeah.
But
Well,
my question is,
we never
If-
disputed that
the
there was an
question is,
easement.
Do you believe that the driveway lawfully exists on Lot 2?
It would have, if it lawfully existed, a variance would have been granted for a commercial connection through a residential lot. It would have been granted for development on the E2 parcel, whatever the block and lot is, on this subdivision plat that you handed out tonight, and there would have had to be a variance granted.
Well, if it were all one lot, and it was all applied for to the planning board,
But it's,
why would it not lawfully exist if mandated by the board, by the planning board?
because that's not what a pre-existing non-conforming use is. It's something that lawfully existed or was granted a variance to exist.
Well, I didn't mandate it, the planning board did.
An-
So what
an
I'm
easement.
suggesting to you is if it lawfully existed, is it still your opinion that it's a pre-existing non-conforming use?
No, my opinion is that an easement was effectuated or implemented, and no variance was given.
Well, are you saying that the town screwed up in that it didn't grant a variance to allow access to?
Well, I've
through-
seen a lot of screw-ups in my 40 years.
I guess my question is, if planning board approval after planning board approval, and there's more, I'm not done, provides that the planning board granted approval for all of these buildings, why are you now, is the applicant saying that this applicant is required to obtain D1 relief over these lots after 40-plus years?
Because the ordinance, the zoning ordinance is very clear.
And it's because only of this application, but if you look at all the prior resolutions and the prior approvals, they were all granted by the planning board.
Those are planning board resolutions.
And you're saying that the planning board made a mistake.
I have seen many resolutions that are in error in my career,
Okay,
yes.
let me move on. Would you, if it doesn't lawfully exist, is it your opinion that it unlawfully exists?
There's an easement, that's not a question, right? That is not a question that an easement exists. But there is a site now that has nothing on it, because your client demolished the building somewhere during the pendency.
irrelevant. Is it
It's
your
very
opinion?
relevant, because my testimony was there's nothing on the site. And so to make this connection, this private roadway go across a residentially zoned parcel, where right now there is no structure on the subject site, you definitely need a D1 variance for what you're doing now.
Okay, is it your opinion that the zoning officer should have issued a zoning violation for the access road based upon the documents I've shown you?
In the 1980s,
Yes.
I don't even know if there was a zoning officer in Bernard's in the 1980s.
Okay. Would you agree that means of access through the existing driveway on Lot 2 was the subject of a previous approval?
Yes,
Are you also aware that the planning board continued to retain jurisdiction over the site plan applications affecting lots 3, 4, 5, and 15 in 2011 and 2019?
yes.
Okay, and I have those handouts if the board wants to see them, but I don't think I need to. All I can tell you is that the planning board retained jurisdiction irrespective of the claim that variance relief was needed for this access easement by objecting planner. Are you aware that in the previous planning board approvals in 2011 and 2009, the approving resolution specifically referenced the cross-access driveway?
Yes.
Is there a difference between an existing driveway that was the subject of a previous approval versus a proposed new driveway that was not the subject of a previous approval?
As I said, there's nothing on the site now. There is no structures
So
on
your-
this site.
Your argument is that because the building was demolished, the variance relief is now required?
Yes,
Okay. So is that a legal argument or is that a planning argument?
as a planner.
Okay. Assume for a moment that if Lot 3 was constructed with a medical clinic use instead of light manufacturing, and improvements were not required to the existing access driveway on Lot 2, would D1 relief be required for the driveway on Lot 2?
Yes, I gave testimony that in my opinion, any new use on the subject site would require a D1 variance for the access.
Well, I'm getting there. Is there any use that can exist on Lot 3? Lot 3, the subject lot, besides agriculture and farming, that would not necessitate a D1 variance on Lot 2? For example, let's say the applicant was to construct a larger office building that would in turn increase the number of cars that would use the access driveway. Would that require a D1 variance?
Any new construction on this site, yes,
Is that
would
a-
require
Is that
that.
a planning argument or a
That's-
legal argument?
I'm not a lawyer, so yes, it's as a planner.
Are you aware that the existing driveway on Lot 2 provides access to all of the uses on Lots 3, 4, 5, and 15 to the east?
I know it connects to the adjoining parcel. Whether,
Are you aware
whether,
that the uses on Lot 4 are not traditional office uses? For instance, RMA is a medical infertility treatment center, surgical center, and research laboratory. Were you aware of that?
Reproductive Medicine Associates located at number 140, yes,
That's
I'm aware
correct.
of that.
Are you aware whether the existing driveway on Lot 2 ever accommodated a tractor-trailer in the past?
No, I don't know that.
So you don't recall the testimony by Mr. Travellini, who testified under oath that the existing driveway on Lot 2 was used by tractor-trailers to access the 150 Allen Road site on Lot 3?
No, I don't recall.
Do you agree that the access driveway in its current condition, and based upon the testimony provided thus far, can physically accommodate a tractor-trailer?
I'm not a traffic engineer.
Well, you certainly had a lot to say about ITE last time.
That was based on cross-examination of the applicant's
Direct
traffic engineer.
examination. It was direct examination. You used the word ITE several times, which implied to me that you knew a lot about traffic. So my question is, do you agree that the access driveway can physically accommodate a tractor-trailer?
I don't know.
During your testimony, you spent a considerable amount of time talking about the crossbar on the access easement, taking away from the, quote, bucolic character of the area. Do you recall that testimony?
Yes, I do.
Can you define what bucolic means?
Rural, undeveloped,
Can I tell you what Webster's dictionary defines it as?
sure.
Of or relating to or typical of rural life.
Mhm.
Is that truly the way you would characterize this area?
Yes,
Are you aware that the crossbar improvements was the result of suggestions or requirements imposed on the applicant by the board's traffic professional?
I thought it was a settlement with objectors
Not
to
true.
prohibit the left turn out of the driveway. That was my understanding.
Well, I think if you looked at the record, it was a request of Mr. Fishinger in his report. Do you believe that the proposed improvements to the driveway on Lot 2 will allow the existing driveway to function more efficiently and safely so as to better accommodate an increase in tractor-trailers?
Well, that was the testimony of the applicant's traffic engineer, and I don't think it was refuted by the board's traffic engineer.
Do you think that these requirements that were imposed by the board and its professionals upon their belief, were imposed based upon their belief that they would provide some benefit to the general welfare?
It was designed to prohibit left turns out of the driveway.
But do you believe that the board's requirement to put a crossbar there was to advance the public benefit?
I don't feel that it's a public benefit to my client, Fellowship Village, to have all the truck traffic forced to make a right turn and go right past their property. No, I don't see that as a benefit.
Under case law, you have to look at not just your property, but the area itself. Is there a community benefit, not just to Fellowship Village, in requiring a crossbar to prevent left turns?
There are over 250 residents in Fellowship Village, and that is, they have one driveway in and out. And all of this truck traffic, which we quantified, the additional, per the FAR variance, that it's excessive. There's no benefit to my client.
There's no benefit to your
No
client.
benefit to my client by this FAR variance.
I didn't go there yet. I talked about the crossbar, and you said, and continually talked about during your testimony, that the crossbar didn't promote the general welfare.
I said it's out of character with the area,
Correct.
not promoting one of the purposes of planning in the MLUL, which is aesthetics,
Right, and.
a desirable visual
whose-
environment.
Whose aesthetics? Fellowship Village or to the community?
This structure that is proposed to limit left turns out of the driveway is going to stick out like a sore thumb. When I drive this section of Allen Road, right in front of the subject site. All I see are trees. There is a freestanding sign there, very nondescript and
I
low
repeat,
visual.
Do you know that this is a requirement of the board's professionals?
I didn't recall that.
Okay. If the board is requiring that the applicant make improvements to the access driveway on Lot 2, could it be argued that the improvements which trigger D1 relief satisfies purpose A, that the proposed improvements do advance the general welfare?
No, no,
Okay, that's your response.
no, because there's many facets to that, and aesthetics is one of them.
Let's turn to the D4 relief for a second. You began your testimony by saying that 6,914 additional annual truck trips are attributable to the 59,189 square feet exceedance of the FAR. Do you recall that?
That was from your traffic engineer's testimony. The applicant's traffic engineer testified to that. I did not make that calculation.
I don't believe that you're correct, because I believe that what we testified to was that the exceedance was based upon the office, but it was not based upon the light manufacturing component, which was at 14.99%.
That's another issue with this application, and there was testimony from your planner, I believe, or I'll say from the applicant's experts, that they were trying to say that the light manufacturing FAR comports with the 15%. There's nothing in Bernard's ordinance that allows you to separate out office, and in fact, the floor plan that accompanies this application, it says light manufacturing, and then in the smaller section of the building, it says light manufacturing / office, or office / light manufacturing. So why that was separated out, why an issue is being clouded, we look at the entire building square footage, and that was listed on the applicant's zoning table as 19.83, whereas 15% is allowed.
Can you define FAR?
That's the ratio of all floors in the building relative to the lot area.
And why hasn't the applicant done that with the 19.83%?
What do you mean, done that?
The applicant has
Yeah, right, we're talking about
identified
two
an
different
overall-
things. Yes, I said in the
Right.
applicant zoning table, they call out the 19.83, but you've been trying to, through testimony, separate out as though we're only supposed to consider the light manufacturing.
I didn't say that. I said,
I misunderstood.
is it illegal or improper, or do you know any case law that says that you can't allocate the FAR space between light manufacturing and office?
For a variance, it is the entire floor area of the building.
I'm not arguing with you. It's 19.83%.
Well, when you say separate it out, allocate what? On your plans, you did allocate separately, right?
Correct, and you don't think that that's, quote, legal or?
Well, that's also on the box that you submitted as a floor plan that shows no uses, no functions within the building. It's on that floor plan.
How can you evaluate the impact of the FAR if you don't separate it out?
Impact the value, the excessive FAR, we look at what's around the site. We look at the impacts to the area. That's what I spent all of my analysis, all of my exhibits were laying the foundation for the fact that this FAR variance has no merit.
Are you aware that the 59,159 square feet, quote, exceedance relates to the office only and not to the light manufacturing?
No, I think in my testimony, I called attention to the excessive FAR in this building is almost equivalent to the sections of the building that are labeled light manufacturing / office.
Well, were you also here when the architect realized that he had made a mislabeling mistake and said that he would correct it on the final plans?
I'm aware that no architect testified on the revised plan.
Were you aware that the engineer testified on the revised plan?
But the architect did not.
I didn't ask you that question.
Well, no one was testifying about the functions that are going to occur within this building and what different uses are going to occur on the floor plans that have been presented. We still, after 2 years or whatever it is, 13 hearings or something like that,
You don't
we have no
recall
more
that
detail
you
on the
don't-
uses within this building.
One of the things that you hang your hat on is that there's this quote mistake in that it's called light manufacturing / office. But you don't recall the testimony of the architect when he said, and he acknowledged that it was a mislabeling mistake and that the mistake would be rectified?
No, I don't remember that.
Okay, do you remember that there was a settlement agreement between the parties? Between
A
my client and one of the parties, the opposition counsel?
The Hills, right, the residents of the Hills, I believe you're
No.
talking about?
It was.
Settlement with who?
I don't remember their
Okay, well, I
name.
don't
It was
either.
Couch Brownsdorf title and the owner of that
I'm not
building.
familiar with this at all.
Okay. Did you read that settlement agreement?
No, I didn't.
I refer you to section 3G of that settlement agreement, which reads as follows.
Hang on, is that part of the record, that settlement
It
agreement?
is part of the record.
I
It was-
don't
it
think
was-
the board
It was
saw it.
presented as an exhibit and presented to the board, and
Can we just check that? Because I thought the board did not see that because we did not want to see it. So just hang on for 1 second.
Did, was something exhibit with, was that, I think something was entered.
Madam Chair, let me reframe it.
Okay.
If the exhibit was
Okay,
not,
can I just remind the public, please, that we're continuing, we're not on break.
the terms were put on the record,
Yes, that is true.
but the exhibit was not. I
Okay.
take
Right.
that back.
Right, that's,
Okay.
right.
So as it relates to, in the settlement, we stated on the record that the maximum square footage of the light manufacturing buildings, inclusive of office space on Lot 3, shall not exceed 244,176 square feet, and the FAR of the light manufacturing space, exclusive of office space, shall not exceed 15%, and the total FAR on Lot 3 shall not exceed 19.84. It ultimately came out to 19.83%.
Okay, so,
No,
but the
that was
total, the
stated
total
on-
number is different than what was on your plan, your latest
Well,
plan.
then
The
you
total
didn't
number
listen
is
to the
different.
testimony where it said, the architect said, I made a mistake and I'm going to correct it.
So what was the number you read as the total for both buildings?
The total is 244, 176.
Okay, but on the plans, it says 244, 128.
Okay. It's still your opinion that there'll be 6,914 additional truck trips attributable to an exceedance of the office space by 59,000 square feet?
No, that is not what I said. That is
Well-
not what I
Or
said.
what did you attribute the exceedance to?
I said that your traffic engineer, under cross-examination, calculated that number. He calculated the square footage excess, which is the FAR variance that's being requested here.
Do you
He
recall-
calculated, can I finish?
I'm sorry, yes.
He calculated that number at 59,189, and he also calculated the truck trips that are attributable to that 59,189. And what I said was that 59,189 is fairly equal to the office square footage for both buildings combined as listed on the applicant's most recent site plan, and that number is 59,551, which I think is close to 59,189. That is the point I was making.
You don't recall that the testimony of the engineer was based upon a hypothetical asked by someone else, and I don't recall who it
This is not a
was.
hypothetical. These
I have to
numbers?
object. I asked that question, and it was not hypothetical, and I would ask that we not assume what's in the record. The board can go back and listen.
Well, I would ask what the board do is look at the architectural plans, the latest plans, that clearly break out the office space and the light manufacturing space. And what your planner has done is use the exceedance on office to allocate it to truck traffic.
That's
And
incorrect.
That's a fiction. That is
That's
le-
a
that is
total
fiction.
misrepresentation of what my testimony was.
I'm telling, my question to you is, was that a made-up, some kind of a made-up story about the exceedance on the truck traffic?
The applicant's traffic engineer was very clear in his calculations, and those are the numbers that he calculated. I believe it was May 16th, if anyone wants to watch the video. I'm pretty sure that was at the May 16th hearing.
The plans are the plans, correct?
Yeah, but you're misconstruing. I don't know what the legal term is. You're making it very confusing when it's
I'm not
really,
confusing.
really
You
clear.
confused it by
No, no,
saying-
no, Mr. Lair, I'm really clear about what I'm saying.
Okay, I'm saying to you that the exceedance is based upon the office space and not the light manufacturing.
Well, I
space.
disagree with you.
Okay.
Because on
You
the floor
disagree.
plan, it says office/LM. It does not say only office.
Let me move on.
Mm-hmm.
Why did you analyze the FAR standard under the Medici criteria, which is used for D1 variances?
I don't think I did that.
Well, why didn't you use the Coventry Square analysis? I never heard the Coventry Square term used once.
Uh-huh, okay. Because
You know
we're
that the
looking, oh,
You know the Coventry Square case?
Yes,
is
I do.
the seminal
Yes, I do.
FAR
Mhm.
case that deals with
Mhm.
the standard to be used in a FAR case,
Mhm.
correct?
yeah. And there's also positive criteria and negative criteria for every variance, whether it's a D1, a D4, a C1, C2. You have to meet both standards, positive and negative criteria. And my testimony was that the increased truck trips calculated by the applicant's traffic engineer, that's 6,914, was going to fail on the negative criteria. And I laid the foundation for that conclusion by presenting very detailed exhibits and giving calculations of how much of the land in the study area is residential, and what the existing environmental considerations are of the study area.
You familiar with the Coventry Square case?
Yes.
And what does it essentially say? Put it in layman's terms. You calculate the FAR, what is the standard?
It talks about that you, under the positive criteria, you're supposed to look at the impacts to the site by the deviation or the relief that's requested and how the site will function.
So it's really, the question is, it's twofold. On the positive criteria, it's whether the site can accommodate the exceedance of the FAR, readily accommodate the exceedance of the FAR, irrespective of the deviation.
Correct.
Okay. And on the negative criteria, it's whether there's a substantial detriment or substantial impairment to the zoning plan, irrespective of the deviation in the FAR.
Correct.
Okay. You've referred to an overall average FAR in your study area. Is that how FAR is measured in the zoning ordinance?
Well, it depends. If you would look at one individual lot, you would look at the building square footage on that lot and the lot area and come up with that. But as you could see from the exhibits that I presented, I looked at a very large study area because I was looking at where the impacts of this excessive FAR would be evident.
Are you aware that the amount of office space has not changed from the original submission to the revised building footprint?
Microphone, please.
Are you aware that the amount of office space has not changed from the original submission to the revised building footprint?
I'm not aware of that. I don't know.
Would it be a true statement that based upon the approvals we are requesting, the amount of office space shown is what the developer has put in place to allow for tenant flexibility in terms of what they will actually need?
Well, I would assume that labeling it on the floor plan as office/LM is your applicant trying to give flexibility to themselves.
Well, I guess you didn't hear again the architects say it was a mislabeling.
I
So we
said
have
I
to look
didn't
at the
remember
revised-
that testimony.
We have to look at the revised exhibits presented in April, shouldn't we?
You're saying he represented that he made a mistake on the plan. I don't know that.
He did. and-
Sorry,
and
Okay,
Ms.
I
Smith,
don't
you
know
gonna say
that.
something?
What I'm
Hang on.
saying to
Hang
you
on,
is
Mr.
that,
Blair.
what I'm saying to
I just wanted to
you,
object because, just so we're clear, you're suggesting that there was testimony by the architect as to the original plans, but there was no testimony to the architect as to the revised plans.
correct, but there was testimony by the engineer as to the revised
As to the
plans.
revised architectural plans?
Correct.
No, I think I objected to having the engineer testify as to the revised plans he did not prepare.
I don't recall that, but I do remember him talking about his plan. Do you remember that? His revised plan?
The civil engineer spoke about his revised plan.
And he did talk.
There was no architect to testify as to the revised architectural.
But the engineer did talk about the allocation between office and light manufacturing space on the revised plan. Correct.
The civil engineer presented his testimony,
Okay.
but he did not testify as to the architectural plans.
Can we present the first exhibit that you had? How did you disturb, this was called OF1, if I'm not mistaken, correct?
I don't remember the exhibit number. I'm sorry. I don't remember the exhibit number.
Cindy, do you know if it was OF1, Ms. Kiefer? Do you remember if this is OF1?
First exhibit is introduced by the planner.
You know, I know there were two of them. I don't have them with me right now.
Okay.
You know what? Hang on a second. I can find out.
I can tell you I looked at the transcript, it's OF1.
Okay.
That's my representation.
Okay.
How did you determine the study area? In other words, what is the purpose of this exhibit?
The purpose of the exhibit is to delineate where I think the impacts would be reasonably observed of this development. And this in particular, it's entitled Land Use, Figure 1. And we're representing the different land use classifications of property in the study area.
Isn't it true that you did not include the I-78 corridor in the study area, even though it's behind the site and is more significant to this site than the uses along Allen Road?
When you say the I-78 corridor, the interstate is shown on the exhibit at the bottom of the map. I don't know what you
But it's not
mean.
included in your study area.
I should have included the highway right-of-way, you mean?
The part that's adjacent to my client's property.
Are we talking to the left of the map? I really don't know where you're referring to. I mean, we tried to follow the boundary of the properties that adjoin I-78.
It's below the site.
It's below the site. Were you a little shaky with our green line, you mean? Is that what you're talking about?
Well, you don't show any of I-78 within the study area, correct?
The parcels adjoin I-78.
But it's not within the study area.
Okay, I'm looking at the applicant's site plan, and I see why our line is not straight on the southern boundary where the properties adjoin I-78, because on the applicant's site plan, it's not straight either. So what are you talking about?
I guess what I'm saying is, did you use this as your study area because you needed to include your client's property?
Well, I was hired by Fellowship Village.
But is it a proper study area as well?
I would say absolutely, because we know all of the trucks are going to make a right turn on Allen Road.
As a planner, and you've been doing this a long time,
Yeah.
isn't it common to assess the impacts by delineating a radius around the subject property or employing other established boundaries to define a study area?
Not for a planning study, no. That radius, that sounds like notice requirements, 200 foot.
What's the planning rationale for this exhibit, since the E2 zone allows light manufacturing?
But we have residential uses in Fellowship Village. We also have farm and open space. We have private open space. We're trying to show what the developed character is of this area.
Did you review the permitted uses in the E2?
Of course I did.
Okay, and you know that my client's proposal for light manufacturing and office is permitted in the E2, correct?
Light manufacturing is a permitted use, yes.
Would the development of these types of uses also impact this sensitive area, as you suggest?
Well, we're not arguing about the uses. We're arguing about the excessive FAR and the other variances that have no merit for this application.
So why didn't you include the east side of the subject site as part of the study area? Does it not have a number of commercial businesses in it?
The east side, we have many areas colored office to the east of the site. I don't follow.
There are a number of commercial businesses further to the east. Why didn't you include that in your study?
Are we talking about properties that front on, I'm going to call it Martinsville, I hope I'm right with that road name. Are we talking about that?
Can I use the cursor, or is there any way that I can
Go ahead,
demonstrate?
go ahead.
What's that? Oh, the mouse, yeah. The areas that I'm pointing to here,
Right, that's,
why aren't they included in your quote study
all
area?
right. Well, they don't front on Allen Road.
Just for the record, that's the area east of the study area on
Yeah, to the east of the green line boundary of the study area.
Would it be an accurate statement that by defining the study area as properties fronting on that portion of Allen Road, you left out properties in the same zoning district as the subject property?
We're the study area is how I delineated it. It's my professional opinion.
Correct.
Yeah,
But why didn't you include other E2 properties in it?
because that wasn't the criteria. What's in the E2 zone was not the criteria. The criteria was, where do I think the impacts are going to be discernible from an excessive FAR variance?
Well, while we disagree with your rationale
Okay.
for how you chose your study area, if a planner were to accurately create a study area with properties fronting on roads to and from the site, those on Martinsville Road south of Allen Road would certainly be included, wouldn't they not?
I disagree with testimony or opinion, professional planning opinion that you're offering, I guess, of where the study area should have extended to the east. No, I don't agree with what you're saying at all.
Well, your determination of a study area is your determination of a study area. Doesn't necessarily mean that it is an accurate depiction. It's your determination of the study.
I have given a foundation, a logical foundation for
Are
my
you aware that-
delineation.
Are you aware that the Seal Spout site at 50 Allen Road is a light manufacturing property?
Yes,
Why didn't you include it?
it's on there. Are you kidding me? It's right across from Fellowship Village.
I'm sorry, never mind. Are you aware that Lot 4 has a principal use as a medical clinic, including scientific and research laboratories?
Can you repeat that, because I didn't hear the whole question?
What's that?
I didn't hear your whole question. There was commotion.
Are you aware that Lot 4 has a principal use as a medical clinic, including scientific and research laboratories, and that Lot 4 also utilizes the access road on Lot 2?
Yes,
Are you aware that the driveway on Lot 2 was originally constructed to provide access to 140 Allen Road, and we talked about that being approved in the 1980s?
as an easement, yes.
When the Reproductive Medical Associates was established on Lot 4, they were not required to obtain a D1 variance for the use of the driveway on Lot 2.
Right,
Where-
I did not see that, no.
Are you aware as to whether RMA transitioned from being an office to a medical clinic with laboratories and research facilities without needing a D1 variance?
Yeah, I don't believe a D1 variance was granted.
Given that the township reviews the master plan regularly, with the most recent reexamination occurring in January of 2023, wouldn't the township have removed light manufacturing from the E2 zone if it had wanted to?
Well, we're not contesting light manufacturing. We're contesting an FAR that's over what's permitted.
Well, you talked about the master plan and its goals and objectives.
Correct.
Isn't it true that the governing body and the planning board have not touched the permitted uses in the E2 zone for decades?
Yeah, we're getting some requests just to be a little louder if you can.
Isn't it true that the governing body and the planning board have not touched the permitted uses in the E2 zone for decades?
I don't know that I would agree with that. As far back as 2010, that master plan that I looked at specifically called out concern about Fellowship Village and quality of life and managing neighborhood character.
I showed you a map from 1983 and 1985. It showed
The
you
subdivision
E2
maps that you-
It showed you the E2 zone district. It goes back as far as the 1980s.
Yeah.
Why are you saying it only goes back to 2010 or 11?
You
or
said that there's been zoning changes. You said over the years
I
there's
showed
been
you a
zoning
map
changes.
showing you the
This
E2
map?
zone
This map?
from 1983. So the E2 zone has existed in its configuration, has existed within the township since the 1980s. So if they really wanted to change it to allow other uses, why didn't they?
Well, that's the E2 zone delineation. I have no idea what uses were permitted in the 1980s. I didn't review a
We go to
zoning
your
ordinance
second exhibit,
from the
please.
1980s. My second exhibit.
In your testimony, this was OF2, the zoning base map, correct?
It's entitled 150 Allen Road zoning, Figure 2.
In your testimony, you argued that this site can't support this use. Do you recall that testimony?
The site can support the use.
That
I said the
you
use was
said that this-
conforming.
Let me repeat it. In your testimony, you argued that this site cannot support this use. Do you recall that testimony?
I said that the statutory criteria for D4 FAR variance was not met.
Are you aware that the applicant strategically designed this site so as not to extend beyond the existing ring road?
I wasn't part of the design.
Have you read the transcript of Mr. Seckler's testimony given on 5 separate occasions?
I've watched the videos and read the transcripts, yes, for all the hearings.
Are you aware that this use will produce only a fraction of what the traffic would have been generated had this been a fully occupied office building?
Well, he limited his analysis to the peak hour.
Are you aware that the slope deviation are less than 1% of the total site?
I gave testimony that the slopes have been previously disturbed.
I didn't ask that question. Are you aware that they constitute less than 1% of the total site?
I don't have the total steep slope calculation in front of me. I only have what variances were requested. So I don't have that. I assume there was a table on the site plan that calculated, I don't
Are you
know.
asking me the question? Or
Well, you're asking me for a number, right? You're asking me for a number. I don't have a table in front of me
Okay.
that would give me that number,
Well,
so I
can
can't
tell
answer
you
the
based
question.
upon my representation that it's less than 1% of the total site.
Okay.
For a site like this, as a professional planner, is it abnormal to have bulk or C variances to bring the site up to modern standards?
The site is, let's get this right. The E2 zone requires a 5-acre lot area, and this is 28 acres.
I didn't ask that question.
Well, that's very relevant to what you're asking.
For a
So no,
site
on
like this-
a site that's 5 times the minimum lot area, I wouldn't expect to see C variances for setbacks or anything like that.
Have you ever testified about a site with more variances than this?
What do you have, 37, I think, was the count by
No,
the?
no, excuse me.
Thir-
there are
37 variances? What?
And there are 7 variances, and there are design waivers.
Oh, oh, okay, so, I mean, it's really a lot.
Do you recall an application you did in Jefferson Township called Industrial Outdoor Storage, where there were 2 D1 variances and 15 bulk variances, and you were the attorney for the applicant?
I was the planner for the
You were
applicant.
the planner?
I
Do you
was the
recall that
planner.
application?
Of course I do.
Okay, so is it, I'm gonna go back to my question. Is it abnormal to have bulk or C variances to bring a site up to modern standards?
I don't know why you're bringing up that application. That was in Jefferson Township, Morris County. It was on a state highway. It's totally apples and oranges. So for you to try to say that I represented an applicant with a lot of variances, and why am I standing here now on this application, saying something different? I'm not saying something different. We're talking about this application and the relief that your client is requesting, and I do not believe, in my professional planning opinion, that it satisfies the criteria for the grant of the variances.
You heard Mr. Seckler's testimony, correct?
Yes?
And he said assume one truck equals 3 cars in length.
In length?
In terms of length of a tractor trailer versus it takes about 3 cars to equal the length of one tractor trailer. That was his testimony.
Okay.
Do you remember that?
I'm not going to refute it if you say that's what he said. Okay.
Even if we assume it takes 3 times a standard car length to maneuver, the access road is not really being intensified, is it? Since there's an overall reduction in trips between this proposed use and a fully occupied office building.
We're not talking about the peak hour trips. That's why Mr. Seckler was asked to do that calculation on an annual basis, because he limited his analysis for this board to the peak hour. But then he also testified that mostly truck drivers avoid the peak hours. And then he also testified that it probably would be peaking for trucks between, I think it was, this was in the Board of Ed letter, so I assume it's accurate, between 11 a.m. and 1 p.m. is what it said in the Board of Ed council letter to the board, where she was recapping.
Do you recall Mr. Seckler testifying about the following numbers? The previous use, 1,884 trips per day. Proposed use, our calculation, and 3 cars equals 1 truck, 1,805 trips per day. The proposed use, the objector's calculation of 3 cars equaling 1 truck, 1,379 trips per day. Do you remember those
No, I
calculations?
don't. No, I don't.
You mentioned that the curvature of Allen Road as a reason to not grant the requested variances. Are you aware of how long this condition has existed?
I don't know when Allen Road was constructed.
Could you pull up your 3rd exhibit, please? I'm getting there, Madam Chair. This was what you identified as OF3, site context.
Right. Figure 3, yep. Mm-hmm.
First, is there a particular reason why you chose to include properties outside of your study area in this exhibit?
That was just a representation of the wetlands and floodplain, floodway, flood hazard area to show that it is much more extensive than just in the study area.
To do a proper analysis, and shouldn't the properties within your study area have been identified as in your exhibit OF3?
I think it would have been awkward if I understand what you're asking me. You're saying, why didn't we just cut off within the green line boundary of the study area?
Well, it was your exhibit. That was your
You're
study
right.
area.
That's right.
And
It's my exhibit. That's right. And that's what I chose to present to illustrate to this board that the environmental constraints do not just end within the study area. They extend quite far beyond the study area, which has implications to everybody in Bernards.
Regarding this exhibit, you testified that the site is, quote, environmentally sensitive, and you relied upon GIS mapping, correct?
Yes, and the applicant also submitted the wetlands delineation mapping and DEP correspondence.
You're aware that the subject site has been developed for decades, right?
And I'm aware that it's vacant now, yes.
And that the sensitive areas in your exhibit are based upon statewide mapping, which is historically unreliable at best. Would you agree?
I don't think it's unreliable, no.
Are there any sensitive areas on the subject property? If there are any sensitive areas on the subject property, wouldn't the NJDEP have jurisdiction over these areas?
There were wetlands delineated by your consultant, your environmental
And didn't my client
consultant.
receive a letter of interpretation
Yes,
on July 18, 2024?
that's correct.
And it identified all of the areas where it can and cannot build because of wetlands?
That's right.
And none of those areas preclude where the development is taking place, correct?
That's right.
Do you think it would be interesting indeed to see how much of the Bernards Township as a community would be considered environmentally sensitive if it were mapped in the same manner you did with your study area?
Well, those maps exist in the master plan of the township.
You testified there is an impact to the master plan by this application, and that the applicant has not put on the record how this site does not do damage to the master plan. Do you remember that testimony?
Yes,
As a planner, are you aware that a master plan is a comprehensive document that includes many recommendations as well as goals and objectives?
yes.
And that the most relevant recommendations at a site-specific level are with regard to future land uses?
The land use plan, classifications, and a master plan are the underpinning of the zoning for a community.
It is a
And the two
mandate.
documents are
Right.
supposed to be
The other ones
consistent.
are- Land use is mandated. The others are discretionary, correct?
A master plan is a planning board document. A zoning ordinance is a governing body.
The land use element of the master plan is a mandate for the board to consider future land uses. Is that correct?
It's a required part of a master plan, yes.
Right. And the other elements are just discretionary.
A housing plan is a mandatory element as well.
Is it not also true that we have already established that the Bernards Township Master Plan continues to recommend the subject property for the uses permitted in the E2 zone, correct?
Yes,
Isn't it true that to cite broad goals related to environmental preservation or wildlife protection is less relevant for a developed property that is already served by infrastructure and located a short distance from an interstate highway than a site that is vacant?
no, I don't agree with that. Redevelopment, which is what I would consider this site since the building on it was demolished. So this is, in my opinion, redevelopment of the site. No, it's all relevant. Every part of the master plan is relevant.
How can you realistically, as a planner, testify that the redevelopment of this site with a permitted use would have a substantial negative impact considering the context of other developed properties and roads that already carry significant traffic?
Well, I've been out to the site and along Allen Road many times during my involvement with this application. And I did not encounter traffic or delays or anything of that nature during the times I was out there. So I think the introduction of all this truck traffic that is related specifically to the FAR overage will be very noticeable and very detrimental.
When you talk about the FAR overage, you're talking about us meeting the 14.99, the 15% requirement?
Yes.
There is no overage.
There is. Okay, we're going to go through it again.
Okay.
I totally disagree with everything you said on that subject.
You testified that the applicant has not addressed the natural and mature vegetation and wildlife. Do you recall that testimony?
Yeah, there's a requirement for tree preservation, and I don't know if I have the numbers, but you're asking for relief from that, substantial relief. So on a 25-acre site, I don't know why the tree ordinance cannot be complied with.
How can you make that statement when the applicant is only developing within, on a 28-acre parcel, is only developing a roughly 5 acres, and he's developing within the existing ring road where development has already occurred?
Well, because we're starting from scratch because your client demolished the building.
You keep saying that, but
We have a vacant site.
that's your opinion, correct? Is it a legal?
I think that's a
opinion?
fact. The building doesn't exist.
Wait,
Please,
I don't
everyone,
think
let's
any
keep-
of this
let's
is
keep
funny,
going.
Madam Chair.
It's not
I don't
funny.
think any of this is funny.
It's not. Continue,
And
Ms.
the
Blair.
question is, we have submitted a site plan to the board that shows development within a ring road. I don't care whether the site's been demolished. The question is, the development that's shown on the site plan is done within the ring road, correct?
Yeah, you're redeveloping at a greater FAR than you're permitted.
Okay, so what's so funny about that? Is it correct to say that the NJDEP wetlands maps are generally inaccurate?
No, they're not.
They're not.
They're not
Would
generally
you rely
inaccurate.
upon the
Well,
wetlands maps?
Well,
If you
this
were-
is why developers have a certified expert go out and delineate the boundaries.
And we did.
I know you did. I think we acknowledged that like
Okay.
15 minutes ago.
Have you ever gone into the field and flagged wetlands yourself?
Yes, I have. It's nasty.
Okay. Have you
Ticks, bugs, you name it. No, not for me. But
Okay.
I understand how it's done now, so.
Okay. Have you ever submitted an LOI to the NJDEP?
No.
Can I ask what the blue area on this exhibit is?
Sure. For simplification purposes, and again, we took this from New Jersey GL Web, which is the New Jersey GIS, and for ease of presentation, we combined the floodplain, the floodway, as one color blue. So that encompasses 1%, 2% flood, and regulatory floodway. We didn't differentiate among different colors. We
So if-
combined
if-
it.
If I were a layman and I were looking at this, wouldn't the blue area imply and suggest it to the board members that this entire area is underwater?
No, not underwater, but under threat of inundation in certain circumstances.
Does the floodplain border the subject property?
No.
How many vehicles of any kind cross through the alleged flood hazard area your OF3 identifies?
There's a bridge over on Allen Road that traverses that blue area, and that blue area kind of goes on either side of Dead River, which in your submission, I think in some of the environmental information, I think you submitted an EIS,
have you-
talks about it being a tributary of the Passaic River.
Have you ever seen or have any history or had any knowledge of all of the blue area being ever inundated to the point that's shown on your exhibit OF3?
I have no knowledge of that.
Was it not your testimony that these two LM buildings are out of character with the surrounding area?
I said the FAR is out of character with the surrounding area.
And many of these uses are non-residential in the area, correct?
Many of these uses. There's a handful of office.
In the E2
There's a
zone.
hotel.
And how about the ones in the E2 zone? They're non-residential, aren't they?
They're office, yeah. Mhm.
And how can these uses possibly be, quote, out of character with the area if they're permitted?
Well, you're not looking for a use variance for light manufacturing. You're looking for an FAR D4 variance for an excessive FAR.
You testified that none of the C variances are warranted and are, quote, self-created, other than the steep slopes, and that none passed the test under C1 or C2, correct?
That's right.
But does this property involve the development of a previously developed property?
It's a vacant site.
Okay, I'm not gonna argue with you, and that from a planning perspective, the whole point of allowing for C variance relief is to recognize that some town-wide or district-wide standards can't be met, but that such deviations are appropriate in specific circumstances.
If the statutory criteria, positive and negative, is satisfied, the board is empowered to grant variances.
You testified that there's no benefit to the public in granting the requested C variance relief, and that the variances do not constitute a better zoning alternative. For instance, you testified that the canopy variance is self-created, correct?
That's right.
While it is true that the strict language of the C2 variance requires the benefits of a variance to substantially outweigh any detriment, have the courts in this state broadened the scope, especially in light of the Pullen decision, which talks about looking at the site in its entirety as opposed to a focused view of a certain area?
We're talking about the canopy?
I'm looking
Or
at-
all the
talking
C
about all the
variances?
C variances.
All the C variances. Well, the applicant has chosen to demolish the existing building on the property and has a site plan application before the board for 2 separate buildings. And they really haven't given an explanation of a proposed user, why 2 buildings are necessary, and they have separated these buildings by about 50 feet. So this is all created by the plan that's being pursued, not by the situation regarding the property, and it is of no benefit to the public or the community at large.
Do you recall during your testimony that one of the board members, and I believe it was Mr. Cambria, asked, wouldn't it make more sense to redevelop the site, even if it requires some minor variances, instead of letting it sit vacant? Do you recall that?
No.
Well, it's in the testimony, I can tell
Okay.
you.
Okay.
So, as a professional planner, why would you ignore the fact that this redevelopment is occurring within the existing ring road?
That's not the criteria for granting C variances.
Doesn't it make a lot of planning sense to redevelop the site within the existing ring road?
I don't understand how that relates to the C variances.
Well, you kept arguing that this is a 28-acre parcel of land, but we have made a concerted effort, this applicant, to develop entirely within an existing ring road. There is no development activity taking place beyond the ring road. Are you aware of that?
Yes.
Wouldn't it make sense to do that as opposed to expanding the footprint and go outside the area that it already developed in?
I
From a
don't
planner's
understand.
perspective?
Okay, I don't understand why there has to be 2 buildings on the site with this 50-foot separation.
In terms of the parking variance, you testified that one should not rely on the ITE handbook for the parking standard, and that the local parking ordinance is not, quote, overkill, as was stated by Matt Seckler. You remember that?
No, I don't.
What site did you review to determine that the town's ordinance is the appropriate standard?
The township has a parking requirement, and this applicant is about 300 spaces short. I think I may have said that in my experience, when I'm representing an applicant and they need a parking variance, I would expect that they would be providing user-specific information to support, if we were looking at ITE standards for parking demand, that they would have some practical, real-life information to give the board a measure of comfort, not just merely stating, oh, we comply with ITE.
ITE is the standard that is used by traffic engineers, is that correct?
Yes?
Okay, and the local ordinance calls for a much more significant number of parking spaces for the office use, correct?
For the office, isn't it 4 spaces per 1,000? Is that what it is for, I don't have it in front of me. I just know that the total deviation is required 610, and with the make-ready spaces, 328 are
So-
proposed.
It's not, is it?
Half,
Is
about.
your opinion that the current zoning ordinance for light manufacturing is not overkill?
The applicant is proposing a total building floor area, combined uses, of 244,128. So if I take that floor area and I divide it by their 328 spaces, I think I come out with a ratio of 1 space per about 744 square feet. I don't know whether that's reasonable or not, because no real-life information was given. No information was given about the potential user of this site and their business operations.
So you didn't do any analysis, independent analysis, to make your conclusion that Mr. Seckler didn't do his job properly in identifying ITE as the proper standard?
I don't think I ever accused Mr. Seckler of not doing his job, or anyone else on your team of not doing their job.
Well, you kept referring to the significant deviation from the township standard.
I don't think I spent a lot of time on that. I don't think I did. I think the numbers speak for themselves. I just gave a ratio, and if the board feels that 1 per 744 square feet is reasonable based on the testimony given by the applicant, then they do.
And you provided no data to support your conclusions.
What conclusions?
The
That you're
conclusion
saying I
that-
said
that-
Mr. Steckler
that
did not,
there's a
I would, first of all, I would never say another professional, even if I inside thought it. I would not say that.
You said that all of the variances, C variances, were self-created.
Yeah, that is not saying that your professionals did not do their job. I don't know where we're diverging to that.
Is it possible, and even likely, that a township's parking ordinance dates back to a time when there was a greater need for labor to support light manufacturing sites?
I don't know that. It's possible.
You went even further by testifying that neither the board's traffic engineer nor our planner challenged the use of ITE as the basis for parking variances, of the parking variance, correct?
They relied on ITE.
You're not a traffic expert.
No.
So why do you think that you as a planner are more qualified to determine the correct standard for parking than the board's traffic engineer?
I did not give a standard for parking.
In terms of the retaining wall and site size, you challenged the variance for the height of the retaining wall in 2 locations on the site. Do you recall?
I cited that at 8-foot height is the maximum required, and I may have gone through the retaining walls that are proposed and the height that they're shown on the plan.
We've established time and time again tonight that the applicant made a concerted effort to keep development within the existing ring road, correct?
You're also proposing 2 buildings, which forces the development outward.
Wouldn't it be a better zoning alternative than creating new disturbed areas on the site by using the ring road?
Well, you're making larger buildings by virtue of the FAR variance that's being requested. And you're also proposing 2 separate buildings, which
So-
utilizes more space on the site.
Let's return to your bucolic reference. You're aware that this site is located next to an interstate highway,
Yes, I am.
close to an interchange,
Relatively close, yeah.
with its character defined by a range of non-residential and residential uses and heavily traveled roadways.
I would also add, there's a lot of open space. I think I gave testimony on the amount of land in the study area that's devoted to open space.
So it's your opinion that the presence of some wooded areas in the vicinity makes this site bucolic?
It's very substantial amounts of property, very substantial. Should I go through it? Because I have the acreage.
I have your
and everything
acreage.
on Allen Road. And starting with I'll call it the park, that's at the, I guess I'll say northwestern end. That's 23 acres. There's a farm qualified parcel opposite that of 58 acres. Pinson Farm is 38 acres. There's municipal open space of combined about 9 acres. It's really substantial. It exerts a huge influence on the character of this area.
Let's talk about the study area, let's talk about the area along Allen Road. Would you consider that to be a bucolic area from Martinsville Road to 140 or 150 Allen Road?
Yes, I would.
Okay. You testified that there are 2 purposes of zoning which have not been satisfied in this application. Purpose A, the appropriate use of land, and purpose I, the promotion of a desirable visual environment. And to support this, you testified that the clearance bar, the only thing you used is that the clearance bar is out of character and a visual intrusion. Do you recall that testimony?
Yes.
You stated that the clearance bar changes the character of the area, did you not?
Yes.
Are you aware that the clearance bar, again, was asked for by the board's traffic engineer?
That doesn't matter to me. How it came to be part of this application is irrelevant, to my opinion, on the impact of the visual character.
I have 2 more questions. During your testimony, you went into areas such as excessive noise, excessive vibration, pollution from trucks, truck impact to schools. Do you believe that you are qualified to make those conclusions in your capacity as a professional engineer?
I don't know that I testified anything about impact to schools. That was the board superintendent that
There
was
was
here.
one reference to 80 to 90 net decibels for truck traffic that you made. I can find you the site.
Yeah, but that's not me saying impact to schools. The schools are a mile away.
I'm not talking about schools.
you
stated
said
that-
schools
that
just
You
now.
stated that I said a bunch of things.
I know,
stated-
but you're recapping my testimony, so it's important to me.
Mr. Blair, can you maybe rephrase the question?
Let me rephrase it. You stated in one portion of your testimony that trucks create between 80 and 90 decibels.
That's right, they do.
Are you qualified as a sound expert to make that determination?
I'm not a sound expert.
So
I'm a
why did you
professional
ma- why did-
planner.
Why did you make that statement?
Because among my 40 years of experience, I've worked on environmental impact statements where I've assessed noise impacts based on use.
So you are a
I
noise
did
expert.
say that any professional planner could pick up an environmental engineering handbook and look at the decibels that would be generated by a heavy truck.
I have nothing further, Madam Chair.
Okay, thank you, Mr. Lair. I think for the benefit of all of us, we're going to take a 5-minute break, and then we'll come back, okay? Okay, I think we're back on? Okay, terrific, thanks. We are back on the record, and I think all board members are accounted for, so that is good. Okay, Mr. Lair, I think where we left off, you said you were finished for now. Okay, excellent. So I know Ms. Phillips-Smith, we're going to have a redirect. Mr. Berlin, do you have intentions of?
I do.
You do?
Yes, indeed.
Is that okay with you, Mr.? It's your witness, so I just want to make sure. Are you okay with it?
For the sake of efficiency, I'd be happy to do my redirect after Mr. Berlin has asked his questions.
Okay. Mr. Berlin, why don't you take a seat? In fairness, I want to make sure that we get to Ms. Phillips-Smith's redirect,
redirect.
sorry, of the planner. So I want to make sure we get to that. So I will allow you 10 to 15 minutes.
Oh, you're surely kidding.
No, I'm not kidding. So just please make the most of it for it's 10 to 15 minutes, and then we're going to have it. I'm sure you want Ms. Phillips-Smith to be able to have the time to redirect her witness.
Well, let me point out to you.
Can you please take a seat at the chair and speak right into the microphone,
telling me to
please?
sit down there.
No. I want to make sure that everybody hears what you're saying, so they can hear what I'm saying. And obviously, we want to give the public a chance if they have anything to say, and obviously, we're trying to get to a position where we can hear public comment also.
Well,
So,
may I make a suggestion? The applicant's attorney represented to you that he would take 1 hour at the last hearing. He's taken 2 hours.
okay, I had heard a longer time, but that's neither here nor there.
I have gone through my presentation. I have had conversations with Jen Smith about trying to do our best not to bring back this witness again. Impossible. My questioning will take,
Go ahead.
my questioning will take, before listening to what went on tonight, my questioning was going to take about an hour. It's going to take a little more than that in light of the.
A little more than an hour. Is
Pardon?
that what you said? What was your time?
1 hour, except in light of the cross-examination that I just heard, it's going to take longer than that.
Okay. In the spirit of getting Ms. Phillips-Smith's ability to redirect on that, I think that is the priority here. So I'm going to allow you 15 minutes. Please make the most of it.
When you say 15 minutes, that's going to be my entire course?
Yes.
No way.
Okay. Do you want to have any time now or no?
I would like to, and I understand the witness can come back. I'd I'd like to continue at the October meeting.
Okay, I don't know whether our planner will be back then.
She
and-
can, we've checked that out.
Okay, I don't know that we're going to ask her back. I'm allowing you 15 minutes. I think it's a reasonable amount of time, especially since it is not your witness. And I think out of a courtesy, we're going to allow
It's not
you.
my witness, but it's my cross-examination.
We'll allow you a reasonable amount of time, which I think is 15 minutes. And then we'll move on.
After the applicant took 2 hours?
Yes.
This is, Mr. Berlin, this is a co-objector's witness, first off. NJSA 40:55D-10D allows the board to impose reasonable time restrictions on testimony.
Reasonable
Question.
time after the applicant took 2 hours? Surely you're kidding.
Again, Mr. Berlin, this is a co-objector's witness.
I
This is
cannot
not,
possibly cross.
this is not an adverse party.
If you want me to start for 15 minutes and then adjourn.
Well,
I'm
I'm
more than
allowing you
willing to do
15
that.
minutes, so you can do what you want with it, but we're eating into it now.
Right. And
So-
not only that, Mr. Berlin, there's also members of the public who may want to ask questions of this
Yeah.
witness. We
All
have to
right,
give them an
well,
opportunity.
we're
plus
just gonna be
Ms.
back
Smith.
again.
So please use the time you have wisely. That's what I would suggest to you.
And after you cut me off in 15 minutes, I'd like to make a proffer of proof on the rest of my.
Okay, do you have, do you want to start? Because that's the most efficient use of your time. Because I am going to call Ms. Phillips Smith back up for her redirect of the planner.
May I call you Donna?
Of course, yes.
And you can call me Don.
Okay, fair enough.
I agree with all you testified to, with one exception. You testified that there was no testimony from the applicant's witnesses as to why the proposal exceeds the allowable FAR requirement by 59,189 square feet. Do you remember? that
Yes,
testimony?
yes.
Okay. What does the 59,189 square feet that the proposal exceeds the FAR requirement, what does that mean?
That's the total amount of square footage that exceeds the 15% allowable.
The office building had a footprint of, if I'm correct, 54,199 square feet, and the proposal has 2 buildings with a total footprint of 244,000 square feet. So the board can get a better understanding of the size of the proposal, of the proposed bill. Well, let me skip that. I'll come back to it. There's something more important if I'm only going to use 15 minutes. Just bear with me. You raised the question as to why they are exceeding the FAR, correct?
Yes,
And you indicated that you didn't know what that reason was. And let me help you out if I can. Just let me get to the portion of my... Bear with me. just having trouble finding what I want to get to, so just bear with me. Here we are. And this to go back. You raised the question, why is Signature Acquisition submitting the proposal that exceeds the FAR requirement? Are you aware that the Vice President and Director of Development of Signature Acquisition testified on August 9th, 1923?
Wasn't
And
born then.
this is a quote,
2023. 2023.
You said 1923, sir.
no, August 9th, 2023.
Yes, okay,
He
good.
understood you.
Good.
I'm sorry.
Oh,
It was
I'm
just-
sorry.
Just an attempted levity there,
And this is the quote. It is important to understand that the rents we can get for light manufacturing spaces far exceeds the net operational income of an office building. He then explained why. The net rent for light manufacturing is $16 per square feet, and it is all income. The net rent for office space is $4 per square feet because of the expense of creating and maintaining office space. And by the way, we thank the Director of Development for supplying that information. I wouldn't have known it if he didn't testify to it. Are you also aware that the Vice President and Director of Development testified on October 12th, 2023? We tried to fit as much building as we possibly could on site without expanding the coverage, the lot coverage. That is the reason why Signature Acquisitions submitted this proposal that is 4 times the footprint of the office building and exceeds the FAR by approximately 60,000 square feet. Is that not correct?
It's close to 60,000, yes.
Is that a reason to grant variances?
No.
If I have to stop, that's where I wish to stop. The rest of my examination, any part of it will go over 15 minutes.
Okay.
Still, you have about 9 minutes, Mr. Mayor.
Okay.
And I want the opportunity at the next meeting to make a proper proof of what I would have asked this witness
Okay,
if
you-
I was allowed to do so.
You may not have that opportunity, so I want you to, if you are going to give up that time now, that's your choice.
My next line of questioning will take more than the remaining time of 15 minutes.
Okay. Then at this time, if it's okay with you, Ms. Phillips Smith, I'd like to ask the public if they have any questions for the planner before you finish with your redirect. There's one? Okay. Please come up.
Guess you could sit at the table if you want to, sir.
Sure,
And I'll remind you just to speak right into the microphone, please.
absolutely.
And name and address for the record.
Sure.
please.
My name is Harvey Gerhardt, 416 Mount Airy Road, here in Basking Ridge. So I've been going through the master plan and everything else. I'm not a planner. Tractor trailers. Did the applicant, in regard to noise, vibration, you brought up noise, vibration, and particulate matter from the exhaust of tractor trailers. Did the applicant's traffic engineer discuss the effects that this would have on Mount Airy Road residential areas going to Route 287?
No.
Do you think that the applicant's engineer should have discussed this, as it would have a major impact on the property values of people alongside that road?
I can't speak to the property values, but environmental impacts are certainly relevant.
Do you feel that the traffic engineer report was valid or flawed in regard to Mount Airy Road?
I can't speak to that.
Okay. Why is there no user-specific details on what is going to happen at the site that is being built?
I don't know. I don't know.
Does the applicant, in your opinion, does the applicant have an obligation to let people know what will be happening at that site?
I think to meet the statutory criteria, any applicant has to give enough support for a board to feel comfortable granting the variances. And the omission or inability to provide that is something that I think this board should consider greatly.
The applicant spoke only about the specific site. Did you see anything about the effect on the rest of the neighborhoods in the area?
No.
The master plan is readily available on the website, and it's worth reading. Did you find any mention in the town master plan as to how the application conforms to the requirements of maintaining the quality of life in our community? And is there anything positive in regard to the impact it will have on adjoining neighborhoods?
No, the excessive FAR variance and other variances will have, in my opinion, substantial detriment to the public good.
Good. Do you find that the applicants properly address the negative criteria that would have on the neighborhood, particularly Mount Airy Road, especially in view of the Board of Education report?
The Board of Education, I believe, questioned at length about the impacts to their schools.
Okay. In regard to, I think I'd leave it at that. When one goes through the master plan that is provided by the township, that's online, there is a tremendous amount of information there in regard to the requirement to maintain adequate quality of life. Let me just go through this here. Do you feel that the master plan violates these goals in regard to protection of open spaces and control and calming traffic in town?
Okay, you said master plan, but I think you meant the proposed plan, right? The proposed plan violates those, right? Those provisions.
Yes, I'm sorry. Does the proposed plan violate the master plan in
yes.
regard to those aspects?
Yes, it does.
Okay. Does the proposed plan, did the applicant provide any negative information in regard to groundwater aquifers, surface quality water, things of that nature?
No.
In the transit from Mount Airy Road to 287, you have to get onto off Allen Road. Does the applicant's plan protect in any way the suburban and rural aspects of our town?
There will be increased truck traffic as a result of this development, and the FAR overage exacerbates that.
The master plan also says that that there are traffic circulation objectives. Do you feel that the applicant falls short here as well?
I think that's more a traffic engineering question than a planning question.
Was there any traffic volume analysis done by the applicant?
They did a traffic impact study, but my recollection is they did, for example, at Mount Airy or Martinsville, that is the same
That's
road,
Mount
I
Airy, yes.
believe, yes. They did not analyze the stacking of the queue at the intersection.
You know, I'm going to object to this. I don't understand how she is testifying as a traffic engineer.
This is not traffic engineering. This is planning, and it relates to the master plan.
No, it's traffic testimony.
All right, guys, let's relax. Mr. Gerhardt, how many more questions do you have? This witness?
Just two more.
Using up a lot of time, so please.
Okay.
Trying to
I can stop there. Traffic problems are not rectified, and the Board of Education problem is there as well, which has to be taken care of.
Okay.
But by the way, Counselor, a
Sir.
car is 14 feet long, a
Sir,
tractor
sir,
trailer is
sir,
78 feet
sir.
long.
You're going to stop right there.
I'll stop.
Can't do that, thank
And we're
you.
gonna
Thank you
strike-
for your time.
And we're going to strike the statements that you made from the record because you weren't sworn.
Not your
Not the length of
questions.
cars?
Not your
Ju-
questions,
we'll-
but
We
your
take your
statements.
questions. This is only the question time. Yeah,
Oh, yeah, sure.
thank you very much. Are there additional questions before Ms. Smith? Okay,
Questions?
questions only.
Please.
Okay, hang on, we're gonna go one at a time, okay? Okay.
My name is Elisa Narsu. I live at 37 Sentinel Drive in Basking Ridge.
Thank you. I know you know this, but just as a reminder, it's questions based upon, the new testimony that you heard. And keep in mind that we're trying to get to allowing the lawyer to,
Okay.
to do her cross. So if you can keep it focused and keep it
I will do
brief,
that.
that would be great.
Yes.
Because obviously, we're trying to get to the public comment. I know you all want to make comments, so
Absolutely.
thank you.
Okay, I want to ask the planner if there was any kind of error made back in the earlier mid-'80s, but then something different is listed in land records now, would the most recent land records take precedent over previous land records? Or how does that work?
You mean if there was an error in a resolution? Sometimes if it's, like if an applicant realizes there was an error or they want to change the resolution, they come before the board and ask for either an excision of certain conditions. But as far as, I think you're alluding to what applicant's counsel was introducing as exhibits and how that flows, I think that's more of a legal issue.
Yeah, I was curious and asked the question,
That's okay. You don't need to explain it.
from what was and what is. I always feel like what is,
Miss.
maybe that's more important, I don't know.
Miss, we-
All right, in your very experienced planning, 40 years experience?
Yes.
In your line of work, what kind of companies have you come across that would need 16 tractor trailer bays? What kinds of companies, light manufacturing or other?
I don't know why they have more loading spaces than the ordinance requires. I don't understand the foundation.
There's no ordinance requirement for loading bays.
I just wondered what types of companies, since
Miss, questions, please.
Okay.
Explain. Thank you.
my biggest question would be what is going to happen at that, what will be manufactured there, but I know we don't have an answer. Okay.
Miss, Again, please, questions of the witness,
Okay.
based on the testimony.
The
that
witness.
she gave.
Okay. Do you agree, I'm wondering, if the proposed trees are taken away and the lack of tree replacement, do you think that would change the topography? And would the taking away of trees trigger environmental changes? Is that possible?
Well, I think what we have here is a site that the building has been demolished, and I think that to restore the ecology of the area, the more trees, the better, since we are in an environmentally sensitive area.
I also wondered about why do people ask for variances? Is it because of hardship that they may have?
Not necessarily. In the land use law, it stipulates the requirements for different types of variances, so it varies.
And my last question is, in the line of work you do as a planner, do you feel that tractor trailer trucks traversing roads where there are 25 mile an hour and 35 mile an hour speed limits, where children ride bikes, scooters, children walk to school, children play, people walk, do you find that this may cause a dangerous situation in addition to the lack of quality of life for the people who live in the area?
The horizontal and vertical curvature of Allen Road is certainly an element of the area that the board needs to be cognizant of in making their decision on this application.
Do you worry, or do you feel that we should worry that it might be dangerous?
The amount of truck traffic that was testified to by the applicant's engineer that is attributable to the FAR variance is, in my opinion, substantial.
Thank you. That'll be all.
Thank you.
Other members of the public,
I
question?
think there was one more question. I think there was one more.
Oh,
Did
miss,
you
the-
sign your name, please? Come, sir, you can come up. If you have a question for the planner, just a reminder, it's questions to the planner. Great. Can you just speak right into the microphone, please? And can we get your name and address, please?
Yes. My name is Rick DeChara. I live at 40 Lafayette Lane in Basking Ridge, New Jersey.
Thank you.
Several years ago, I had a stroke, and I'm constantly walking out on Mount Airy Road. And many times during school hours,
Sir, I'm very sorry. I'm not trying to, I understand you had a stroke, but you need to ask a question.
Yeah, my question is, what sort of safety features do you have for all of the high school children that are on the end of our street waiting for the buses to come, and when the roads get plowed, they have to walk over these big piles of snow and literally stand in the road? How has that been addressed?
That's a question for the applicant, I believe.
Sir, just to be clear, Ms. Holmquist here, she's been retained by Fellowship Village.
Right.
She is a planner testifying against the application. It seems that your question should have been directed to the applicant, the one who's proposing this. She is not here to support the proposal. She is here to do quite the opposite of that, quite frankly.
Okay.
So I think that question is more intended for another witness.
And that's-
I don't know if your questions are related to the proposal itself,
Yeah.
but this is not the witness that you would
Yeah,
want to be asking.
and as a reminder, everyone in the public is going to have an opportunity to make a comment. We'll
Right.
give you some guidance around that.
Right.
And that will be the time if you want to make some statements
Right.
and testimony. That's a different thing that we're
Okay.
doing right now. Okay?
Just there's certain procedural formalities we need to follow.
Yeah, no, I understand.
Yeah.
Thank
Okay.
you.
Oh, sure.
Thank you.
You're okay. Thank you, sir.
Okay. Are there any other questions from the public before Ms. Phillips Smith comes back? Your name and address, please, and right into the microphone, please.
Karen LaRosa, 11 Morgan Lane, Basking Ridge. That's up in the hills.
Thank you.
Very briefly.
Sorry,
are-
right
Are you
here.
aware,
Get
are
really
you
close to
aware
it.
of whether there are any development easements on any properties within the close vicinity of the proposed development?
I'm not aware of that.
You're not aware of whether there are any development easements
The
on that
easement
same
that
property?
that affects this subject site, that I'm
Okay,
aware of, yes.
So you're not aware. If there were development easements that were paid for by the township, county, or state on the same road, would that support your, what you've declared to be a bucolic nature? If the town was taking development easements to stop development or maintain trees?
Oh, conservation easements, I
Conservation
think you're
easements,
talking
right.
about? That's a relatively common thing with environmentally sensitive properties. It can affect residential properties as well. I think that if the township were implementing conservation easements, it would give support.
I'm sorry, when you say conservation,
Well,
I mean.
I guess I'm misunderstanding you, I'm
not
sorry.
talking about, I'm talking about specifically development, as in the property owner holds the property. We're not talking about conservation easements for wetlands. A development easement so the property cannot be further developed. But in general, development rights.
Okay.
Would that tend to support the area being deemed bucolic?
That's done with farmland frequently to prevent development and transfer the development rights to an area that can handle more intense development.
Okay. The English Farm, is that, I'm not sure if you're aware where the English Farm is. You can.
It's north
In the
of-
Liberty Corner section.
Yeah.
If you're not from, I'm not sure if you're familiar, but was that included in the study that you did? I
No.
wasn't able to catch that.
No, the study area was delineated with the green line in my
I'm
exhibits.
sorry, I couldn't see whether or not it was. And in your testimony, you seemed, I'm sorry, as a planner, is there typically a planning value to something such as the blocking the turns to prevent trucks to go into a residential neighborhood? Is there typically a residential value in directing trucks away from residential areas?
Yes, that protects the character of the residential area.
Okay, that's all.
Thank you. Any others? Okay. Ms. Phillips Smith?
Madam Chair,
Yes.
I had one question.
Yes.
Are we gonna ask after, are we gonna ask questions after the redirect, or do we do that before?
Probably a good idea.
You can do it now.
Do it now before the redirect?
Give her a
Yeah.
chance, yeah.
Okay, so I just have like one thing about the D1 in your testimony tonight around the D1. I just want to be sure I understand it. Your testimony is that any construction on the site would require a D1 variance of the access road?
Yes,
And if it's the same use there, and
the same use as,
meaning
well,
there wasn't a change,
if there's office. If this application was for an office development.
yes. But the access road was going to be modified, meaning it was going to be widened or changed or anything like that. To change that road, would that require a variance?
My opinion is that any development on this site, because there is now nothing there, would require a D1 variance for access across the residential zoned property.
But if they just were going to, if they were going to keep the, I know it's hypothetical, I'm just trying to understand it. If they were going to keep the building that was there, but they wanted to change the access road, and they wanted to widen the access road, or they wanted to make any changes to the road itself, would that require a variance?
Well, there is a section of the code that prohibits non-residential access through a residential zone property. So I don't know what the ordinances said in the past, but based on my reading of the current ordinances, I would say that it would be prudent to get a D1 variance.
If the planning board or whatever was put into these documents comes out to be accurate, or the way in which it was
The
portrayed.
information from the 1980s that was shown to me tonight?
The planning board permitted this access road, and then it was built. Does the owner then have the ability to change and widen that road and put structures over it in any shape or form after it's built and been permitted?
No.
Or do they need to, would that require variances to widen or build things around the road?
Based on what I saw tonight, no variances were granted. So I think a variance is needed.
Thanks.
And that's regardless of any variance that they're asking for.
Yes.
If all they wanted was the canopy, if that was the only variance, in your opinion,
would
they
still-
need the D1 because they didn't have it.
Yes, because my reading of the ordinance is that that is not permitted, and no variance was ever granted, that I can tell, for that, and so they would need that now,
Thank
yes.
you. Any other questions from the board? Okay, sorry, Ms. Phillips Smith. Thank you for allowing some additional questions.
I'm going to keep this actually very short because I know the time is tight tonight.
Well, you can have as much time as you want, so it's your witness. So.
Thank you. Just going back to clarify a few items that came up during cross-examination. So first, is the applicant a public utility?
No.
Were you present for the testimony of Mr. Hughes, the applicant's planner? Or did you review the testimony?
Yeah, I think I watched the testimony, yes.
Do you recall if Mr. Hughes gave detailed testimony concerning when the driveway on Lot 2 was approved and constructed?
No. No.
No,
I
you
don't
don't recall,
recall.
or no, you don't believe he did?
I don't recall. It's not coming to mind.
Okay. Even after all the representations that were made this evening, are you aware of any prior approval that allows the driveway on Lot 2 to be used to service an industrial use?
No.
We talked about, or Mr. Lair talked about the Coventry standards.
Yes.
Is it your opinion that this site will accommodate the problems associated with the proposed permitted use, but with the larger floor area than permitted by ordinance?
Well, that necessitates the C variances. And then, as a planner, I look at is the statutory criteria met? And in my opinion, it's not. I don't know if that's answering your question.
So just in short, do you believe that the statutory criteria for a D4 variance has been met by the applicant?
No.
And along those same lines, even after all the questioning tonight, is it still your opinion that the applicant has not met the statutory criteria for the granting of a C1 or a C2 variance for any of the variances requested?
That's correct.
That's all I have. Thank you.
Okay, thank you. Mr. Lair? Anything else from you? Okay, thank you. 10:25. Okay. I assume, there's no more witnesses, we don't think, at this point in time?
Not up, no.
And Ms. Smith, no more witnesses for you?
I am not presenting any additional witnesses. Thank you.
Okay, all right. Lo and behold, we might be at public comments.
Not tonight.
Not tonight, but we might be there.
I do just have one clarifying question. At the end of public comment, before we go into close, before everything is closed out, I do think we need to deal with the exhibits this evening and whether they're being intended to be moved into evidence despite the fact that they were not, identified by any witness.
We can have that discussion.
Thank
At
you.
a later date, and we won't do it
Thank you.
tonight,
Yep,
right?
but it's noted, and we'll put that.
Thank
Okay,
you.
we will get back to you. Okay, so I think we're going to carry this hearing to the 9th. Is that right now, Ms. Kiefer?
That is correct.
Okay, we have no residential cases booked on that night. We have the 9th for signature, which is our regular meeting time. Okay. So we're going to carry
Yep,
this without
so
notice? Or what
That
do
is
we
the,
do?
I'm hereby making the announcement, Madam Chair.
Okay.
This matter will be carried to October 9th, 2024, 7:30 PM right here in the municipal building of Berners Township. This is your notice, me telling you this. The applicant won't be required to renotice, at least at this point. So yeah, if you want to come back, the anticipation is that we're going to start public comments on that date. We'll see how far we get.
Yeah,
So-
can I just ask by a show of hands of people here tonight, how many people intend on making a comment? Okay, that's okay, that's okay, I see the hands, I see the hands, and I assume there will be a few who might not be here.
No, we're not.
No, we're not doing it tonight, thank you. Definitely, we are not doing it tonight. Let me just share a couple of my thoughts just around public comments. I appreciate that there are a lot of people who want to make a public comment, and the board's going to make every effort to hear each person. And in that spirit, I'm going to ask people, as they think about their comments, to keep them focused and try to keep it in a length of 3 to 5 minutes. The board will have discretion around people who come up, but in fairness, I want to give everybody an opportunity to speak. And, out of respect for everybody's contributions, I'll ask you to keep your comments to 3 to 5 minutes. Just as a reminder, we're going to try to avoid duplicate comments, and I appreciate that you're going to work on them at home and be ready to speak. But remember, we want to always be respectful for people who are making comments either for or against the application. The board's going to hear them all. So we expect to do that at this next meeting.
I just want to ask a question for clarification. Ms. Holmquist is now finished, correct?
She's finished.
And not expected to return,
She is
correct?
not expected to return.
Thank you.
Not at this point in time, thank you. And then just so the public knows, we'll do public comment, and then it'll go back to the attorneys to do summations before the board deliberates. Okay? Okay.
All right. Thank you all.
Thank you for that. Keep in mind that our meeting is not officially over, so if I could ask everyone to remain quiet. You don't have to remain seated, you can leave, but just so that we can finish up here. Are there any comments from members?
Michael, let's talk about this some more.
What's the process going to be when you have people for comments? Are you going to have them sign in?
Yes, we're
And
gonna
then
have, yes, we're gonna have a process where we can try and have a couple of people online. We'll have a sheet, to sign, if people are represented, by, They can. So people who are represented by council, they can still make comments. So there's going to be a fair amount of those. Yes, there will be. So we're going to try and keep the process moving, but obviously, if there are a large number of people and it's 35 minutes, it's a long time. So we're going to try and make a line, and we'll give them instruction, and we'll try and keep it moving the very best we can. I think we tried to remind them about duplicity of comments, and that's hard because people prepare their comment, they're ready to read. So we'll try. We're going to do the best we can. From the meeting schedule, Cindy, I think we have, in theory, we have both meetings blocked off for signature, right? October 9th and October 17th is a special meeting, so.
Both the 9th and the 17th are blocked off for
Signature.
Our next meeting, that will be a small application, will be the first meeting in November.
Will be in November. Okay, so we haven't made a decision on the special meeting yet, but we know October 9 for sure is going to be signature.
The plan,
Okay? No. That's okay. Yeah. Mr. Kraus and Mr. Halverson, do you know, we can cross that bridge when we get there, but if you guys could check your schedule for October 17th, because it seems like we may not have a quorum, so we'd like to know that in advance. So I'll ask every member of the board to just check their calendars, and if you can email Ms. Kiefer with your availability or lack thereof, that would be great.
for October 9th, October 17th?
Yes.
And then if it's not October 17th?
It wouldn't be until maybe on November 14th, but for now, let's just focus on.
Next available meeting, if we don't have after the 17th, the next available meeting for signature would be, I believe it's November 14th.
November 14th. So for now, let's just focus on October, because we know for sure it'll be October 9th. I assume there could be some spillover onto the 17th, but if you can check your calendars and just let us know. But for right
So-
now, all we're saying is the 9th.
So if we do the 9th and the 17th, 9th is public comment, 17th is statements and deliberation?
It could be, if we finish public comment on the 9th. That's the way it would lay out. Are there any comments from staff? Thanks
I
very
do.
much for coming on this special night. Thank you.
Chairwoman,
That was very vague.
I do have a comment for you, all of you. Ms. Chairman Janier, Chairwoman Janier, Mr. Cambria, Mr. Kraus, Mr. Helverson, and Ms. Herrera. You need to respond to me a statement of interest.
Ms. Kiefer, it's a bad time to ask people.
I realize my time.
I see that email, I'm like,
I realize my
it's a tough time to do that. Give us the maximum amount of time to respond. Motion to adjourn?
Motion to adjourn.
Second? All in favor? Thank you, everybody.